Attorney Jamal Green. 25U567473. Your name?
Jamal.
What brings you here? You've had a year to pay this, right? The ticket was issued on St. Patrick's Day in the year of our Lord 2025. You didn't show up in April. You didn't show up for your show cause in August. And now here you are, and you're going to ask me for time to pay. See how smart I am? I mean, it's just a replay. How much do you have today?
I don't have anything.
Why not?
Well, really, actually, I forgot about
You
it.
forgot about it.
So,
That's a wrong thing to tell the judge.
well, what happened was,
Did you hear what I said?
yeah, it is.
That is the wrong thing to tell the judge. I forgot about it. Okay? I don't know how you can forget about it. I want to forget to pay my taxes. You know what I mean?
Yeah,
I want to forget to pay my mortgage. Where do you work?
I actually do transportation, but I was actually going through a separation with my wife, so I hadn't been out here. And I totally slipped.
You make it sound like you live in Brownstown, right?
Yeah, but we're doing a separation, so I kind of stand rumless these last, like.
It's not that far.
Yeah, but I didn't get the memo, so it was like, it was
Didn't get the memo.
Just my house, it was a little off, so yeah.
How old are you?
I'm 40. But
Time to grow up, don't you think? Tell me when you're going to pay this.
in 4 years, something?
I can give you a payment.
No, I just want the warrant because I got.
I'm not lifting the warrant. No, listen to me. You just want the warrant lifted. Why do you need the warrant lifted? So you come in here and you want me to do you a favor when you've been spitting on us for 11 months and now come in here 11 months and now come in here and tell me I just want the warrant lifted. Maybe I don't want to lift the warrant. Maybe I want to send you to jail. You think I'm kidding, don't you?
No, I don't think you can.
What do you need the warrant lifted for?
I mean, because I drive.
Well, maybe. Listen. You have ignored us completely for 11 months. I don't want to hear I forgot about it. That's not an issue. You didn't forget about it. And if you forgot about it, then you're even more irresponsible than I think. And that's hard for me to imagine at this point. I want the warrant lifted. I wanted to be president. We don't get everything we want. You come here with no money. Why aren't you working? You said you do some transportation. How much do you make?
I make 18 hours,
How many hours do you work?
like 7 one part sure.
70?
7 hours a day is like we get about
How many days do you work?
4. We got
4?
Thursday, Friday, Saturday, Sunday.
So you work 28 hours a week. Why aren't you working more? Prime earning years of your life. 28 hours a week, $18 an hour. That's somewhere in the neighborhood of $520 a week gross. You gotta make more. Did you graduate?
Yeah.
Why aren't you working?
I don't know, Barbara, it's just been slow, so I just do transportation.
I wish everybody could do this just for a couple of days and we'll find out how irresponsible society is. You know that?
I can pay it on the first.
The whole thing?
Yeah.
Where are you going to get that kind of money?
I'm gonna get it from my dad. Well, for Middleton. I just wanted to get this cleared up.
I'm going to let you pay $50 a week and we're going to start this beginning. Now, I don't care if you want to get it from your dad, you get it from your dad. Pay $50 per week beginning February the 20th. If you don't have the money, I'm reissuing the warrant. Okay? If you call the court, you say, Judge, I don't have the money, I had a bad week. No problem. But you can't do this. You got to act more responsible than this. So you call the court. If you don't have the money, no problem. Call the court. We'll go on Zoom. I'll give you an extension. Stop ignoring courts. It's a bad habit. Good luck. Knights Lane Holding LLC. You're all set. 25B82558, 25B82632.
The voting. Okay, where's the vote?
Ma'am, what is your name?
So that's
Whoa, 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 whoa. You gotta go 10 times as loud as that. Nice and loud.
already.
What is your position with Knights Lane? You're not a lawyer, are you? Or are you?
You.
Listen, so now this has blossomed. Actually, this is Judge Heston's case, isn't it? Heather, I think this is Judge Heston's, right? Or not? Oh, you got show caused. You show caused the owner. Where you been? Why haven't you shown up?
I was trying to coordinate with the city about this, and I already
We've sent notices out.
the one that I
Wait a minute. I want you to listen to me. I can't hardly hear you. You haven't shown up in this courthouse on 2 different dates that we gave you. And now we had to show cause you as the owner as to why you shouldn't be held in contempt and be sent to jail. Listen, you need a lawyer, and you need a lawyer fast. You need to hire a lawyer. You can't represent the corporation on a criminal case. Why you been blowing us off? Now keep your voice up. I need to hear you. I can't hardly hear you.
no, I needed to come to court. This was the first time I saw the notice that I needed.
Heather, is this not Judge Hudson's?
Judge, there should be 2 cases for Knights Holding. One is ours that she needs to be. Oh, wait, you know what? Now that I'm looking, I'm sorry. The one that she needs to be arraigned on is showing it falls under her. But let me just double check that date. I also did, while I have you on here, receive a phone call from an attorney at the end of the day yesterday saying that they were going to be retained. They just couldn't make the court date today, but they never filed a
As far as that, they know better than that. We're not adjourning everything. So a lawyer, I'm sorry, if we don't have an appearance, as far as I'm concerned, the lawyer who purportedly was going to represent them is not the lawyer representing them. It's basic. They should have known that the first day they got out of law school.
So, Judge, I'm looking in the non-payment one is ours, and the one that she
I
has
see.
never been arraigned on is Judge Heston's.
Here's what I'm doing. I'm rescheduling these. Can you spell your name for me again?
Odessa,
Odessa.
it's the company Odessa, and last name Codilla.
Codilla. All right. I'll just make a note you appeared. We're rescheduling this. You need a lawyer. Reschedule. This is going to go primarily on Judge Heston. So what are we doing? The 25th?
That would be a crossover on our day. We could do that though.
Well, whatever day.
Or she has them on March 4th.
What's that?
March 4th, Judge Heston has Brownstown.
Does anybody have Brownstown next week?
She does have it on the 18th, yes.
I'm going to reschedule this to February 18th. We'll do it 9:45. You need a lawyer, okay? I mean, we sent the ticket. You got to be careful with this. This ticket was issued back in April of 25.
Your Honor, for some reason, I saw the ticket last month, and I was trying to coordinate with the city about how to go about this.
Here's what needs to happen. They think this is what happened, just so you. They wrote you for failure to register your room. When you didn't show up on the civil infraction, it turned into a misdemeanor. So now you have a civil infraction you're in default on, that the company is in default on, that they owe 198 on. And you got, You paid this?
I think that, when I became aware of it, I've been asking the city how I can pay it. And initially we misunderstood because I couldn't find it online. And then
How'd you pay it? Did you pay it through?
when I was able to, I kept trying something because I was finally able to talk to somebody yesterday to get assistance that could guide me in it. And then they told me how to pay, but initially
All right, let's slow down. Did you pay it at the court?
the online payment system.
Do we have,
I do not if she paid it within the last couple or the last 24 hours. Prior to that, it has not been paid, Judge.
It went through yesterday, the payment
how long
file.
does that take for us to figure that out when they pay
I
on?
can- If she used the one system, I can look right now. I'm gonna look. and
Yeah,
see if-
look now, and I got a better idea if she's.
Ma'am, did you pay on the site that charged a fee?
E-courts, mentioned the e-courts,
I'll tell you what I'm gonna do.
Yeah, that did not go through, Judge. We don't have no payment.
they emailed me the receipt though.
Well, listen, here's what I'm gonna do. I'm gonna let you go down the hall. You see if you can resolve this with her. If she pays this, I'm gonna send it to Brownstown. They might just go ahead and dismiss the misdemeanor. But I need proof. So can you figure that out? Do I need to send the file down or can you do it with her just going down and showing you her receipt?
She can come down with the receipt and we can look at it.
Go down there and we'll figure something out, but you can't ignore these things, okay? All right, go down and talk to her. We'll see if you paid. If she has, tell me, I'm gonna call in Ms. Foley Carter on this, okay? Thanks.
It's
You're gonna go out that exit, see the doors in the back, and then go all the way down the end of the hall, okay? All right, thanks. National Electric LLC, 26B82503. Good morning, council. How are you?
Good morning, Todd Barrett, on behalf of National Electric.
So, you registered with the company registered with the township, and they're gonna just go ahead and dismiss, right?
That's my understanding. There's a motion to dismiss. We have no objection to that. We have verified. They have registered with the township, and then any issues with a permit or inspection have been handled. So-
Okay. All right, good enough. They moved to dismiss, case dismissed. Good to see you, Mr. Barrett.
Yeah.
You take care. Which one do you have?
I have Mr. Wilson. He is in the street spot blowing in the solar link right now.
He's what?
He's blowing in the solar link right now.
Okay,
Yeah, 9 o'clock. So,
okay.
he's
No problem.
here. He's just,
Did you talk to the prosecutor yet?
we're ready to go.
Okay.
Oh, you know what? Oh. Wilson. Are they here?
James Sparrow, on behalf of Mr. Wilson in this matter.
Sir, your name?
Reginald Wilson Jr.
All right, so we have a charge of super drunk. We have a charge of PBT refusal. He's going to plead responsible to that charge, PBT refusal. They're going to dismiss the super drunk. He's going to plead guilty to operating unimpaired. True?
That's correct.
Is that what you want to do, sir?
Yes, sir.
If you do that, possible penalties are up to 300 fines, 93 days jail. 300. You just had a case.
2 years ago. And this is a sobriety court change. Or a sobriety court fraud.
Oh, it's going to be, is that right?
Yes, there were notations on the other plate.
Okay,
And I can let you know, he does have his sheet, he, is doing sober link, and he has already had an intake at 2 sessions with a counselor at Dollar Grades. We went over the sobriety court checklist, and he does want to,
he understands I have to immobilize his vehicle today, right?
Today, we talked about that, Your Honor. Yes.
Okay, so if you plead guilty to operating while impaired, the possible penalties are up to 300 fines, 93 days jail, 360 hours community service. Court costs are all of those. 4 points will be added to your traffic record. Your license would be suspended or revoked, in this case, revoked. Your vehicle could be or might have to be immobilized. It will have to be immobilized. So I'm gonna have to order that immobilized. Your license will be revoked, effective in the next couple of days. Do you understand that? I can't hear you.
Yes.
Did you sign, read, and understand an advice of rights form here today?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes, sir.
Do you have his AA verification?
Yes, I've seen it. He got one.
That's all right. I don't.
Yeah, yes, Your Honor.
Has he been going 3 times a week?
Yes, he's got 11 or 12 at this point.
All right. So you understand everything that's going on here.
Yes,
You understand what a commitment that sobriety court is?
yes, I do. I've read all the paperwork.
So you're going to have to come to status reviews every other week with me, either at 7:30 or 3 on Wednesdays, 7:30 in the morning or 3 o'clock in the afternoon. You're going to have to meet with probation in the off weeks. You're going to be going to AA 3 times a week, going to treatment, going to an armed program, testing 3 times a week during your bond phase at your own expense. Once you get accepted into the program, we will pay for the testing and the sober link with our grant, so long as you test every time and you test negative every time. Do you understand that?
Yes, sir.
All right, I just want you to be aware, because there's no way you get through that program unless you're 1,000% committed.
And Your Honor, one other thing I can say is that we know somebody mutually who was kind enough to talk to him that has been through a program in a different court. That's this Friday court in Lincoln Park, and he kind of gave him a heads up on what the expectations are and how the program really helped his life.
Good. All right, so you want to do this.
Yes, sir.
You understand all your rights.
Yes, sir.
You understand the possible penalties.
Yes, sir.
To the charge operating while visibly impaired, how do you plead?
Guilty.
Were you operating a motor vehicle on November 13th of 25 on Sibley near Racco in Brownstown at 8:25 p.m.?
Yes, sir.
Prior to that, did you drink alcohol? And if so, what did you drink and how much did you drink?
And a few Jack and Cokes.
All right, how many's a few?
4 or 5 maybe.
All right, and was your ability to operate the motor vehicle impaired due to the consumption of the alcohol?
Yes.
In what way? Why were you pulled over by the police?
We're speeding, swearing.
Do you think you were speeding and swerving?
The good possibility, yes.
And you think you were speeding and swerving at least in part because of your alcohol consumption?
Yes, sir.
Was this an intoxilizer test or was it a blood
It was
test?
blood.
And you stipulate that it was accurate, that is a .199?
Stipulated.
Are you on probation or parole right now?
No, sir.
Were you in front of me on the other case or Judge Hessen or somebody else?
You, sir.
Anybody force you to plead guilty?
No, sir.
All right, I'm gonna accept your plea into the charge of PBT refusal, responsible or not responsible.
Responsible.
I'll accept that plea. I'm going to dismiss the super drunk charge. I'll accept the plea to impaired, accept the plea to PBT refusal. And I'll refer you for a screening and assessment. I hope. So we're going to have sobriety court on Wednesday next week, okay?
Yep.
So you'll have to make up your mind whatever one is easier for you to attend. So this is a sobriety court case. We're going to put it out, Heather, probably till. Let's see, let's go to like the week of the 18th of March.
Okay, so yeah, you have March 18th and you want to do 8:30?
Yes, that's perfect. March the 18th at 8:30. So you'll go fill out a questionnaire and you'll be interviewed. I'm ordering the mobilization of your vehicle. You're going to have to prepare that order, Heather. It's going to be for 90 days. And you have to have all that done by February the 18th, 1 week from today. So you have to have the vehicle immobilized. Probation will give you all your other bond conditions. And we'll see you back here then. I'll defer the sentencing, by the way, on the civil infraction of March the 18th as well at 8:30, okay?
Thank you.
I wish you well. I look forward to getting to know you and hope we can help you.
Yes, sir.
Good luck. Thank you.
Probation first, Judge. Thank you.
Yes,
Thank you.
and then he can get his notice. Or have a good day. Thanks. All right, Leslie Bolsujor versus Cynthia Hernandez. 2504922.
Right to the podium. Stand right next to him.
You all right?
Yeah,
Okay, tell me your name.
Jessica Hernandez,
Your name?
Leslie Bolsonaro.
Aaron. Do you two want to go talk about this before I start swearing people in?
No, I don't.
Just relax. Let me just read something that's attached. Wow, you did actually draft something here. I don't know who drafted this for you, Ms. Bosajor, but I could make a case that this is a security agreement. I'm going to do this a little different. Right now, the car is titled only in Ms. Hernandez's name. Bring any documentation with you that tells me that you made the payments?
Me?
Yeah,
I
you.
did.
Now, before we go on, I'm going to scare everybody to a note. And I'm going to try to do this a little different. But I want you to know you're under oath. I'm going to ask both of you to raise your right hands, please. You solemnly swear or affirm under penalties of perjury that the testimony you'll give of these proceedings will be the whole true self you got. Ms. Bosajor, Ms. Hernandez?
Do.
Let me see the proof that you have that you made the payment. She attached to her complaint documentation that does spell out that you were to pay $3,000. And there was a payment made on October the 2nd that you, by the way, initialed of $500. And again on November 5 of $500. Do you have any more documentation that indicates that you made any other payment?
What I have.
Let me see what you got.
Let's do that right there. And then that. That's her.
Whose writing is this in?
Not right. And then on the back is what you was right.
Oh, wait a minute.
Those are my notes and then.
Ma'am. You're under oath. On the first two payments, you guys both initialed the $500 payment. And then you just added 2,000 paid on September 25th that you wrote on the back of this, right?
That was the notes I kept from the day that we put the car in my name, the day of Secretary of State that I gave her money. That's when the title that I had went into my name. She kept notes, I kept notes. Oh, I wrote a contract. Yes, speak your own.
No. I want to know if that's your story and you're sticking to it because you're under oath. This is going to be easier than I thought. Are you telling me you paid her $2,000 on September the 25th?
Yes.
How'd you pay the did she pay you 2,000 on September 25th?
No, absolutely not. Didn't have the money. She had to bail herself out of jail. That's why I offered her my college.
Come on. Come up in front of my report. Show her that document. Did you ever see that page?
No.
I neither. Mr. Hernandez, who do you think that you are coming in here and trying to
What?
put that back? Give me that back, please.
Hostel business.
Who do you think you are coming in here with notes on the back of that document,
That is horrible.
expecting me to buy this? And now you come in here defiantly and no, I don't want to talk. I don't care if you talk. You owe her $2,000 at minimum. Okay? How are we going to resolve this?
I can talk.
I'm sorry?
I can talk. You said I don't want to talk. I just want to be asked. If you asked me a question, I will definitely answer it.
You didn't pay. You didn't pay her.
On September 25th at the Secretary of State. And here,
September 30th is when you guys executed this other document. You signed it October 2.
that was when I gave her $500 on October 2nd.
Yeah.
2 payments.
I don't want to hear it. I don't want to hear it. I don't believe a word you're telling me. I don't believe a word you're telling me. There's nothing here that would add up to you paying $2,000. So if you want to act like I can't add 2 and 3 without a calculator, just you continue doing that. You're late, Mr. Robertson.
Everything was cash, Your Honor.
I wouldn't expect you to, ma'am. You're in a courtroom. Okay? I don't want to hear another lie. You're in a courtroom. There's nothing here that adds up to you paying that $2,000 in cash. This was dated October 2 by you. This first page. Is this your signature?
Title is dated 25th of September.
Ms. Bosajor. You come up here. You come up here too. Whose signature is this?
My signature.
Okay. Why would you sign something October 2 saying that you agree to pay $500 per month beginning October 1 with the last payment due on March 1? That would be 6 payments at 500. 6 times 5 is 300. Now you come in with this cockamamie document on the back that you hand wrote and says you paid $2,000 on September 25.
That was the second document that was made up. There was copies.
Well, you're behind. It's 82-0. There's 2 outs, 2 strikes, and nobody on. Don't lie to me another second. I'm gonna really get agitated here. I told you not to lie to me when you came in here. I told you not to lie to me the other day. I sensed that you were going to come in here and lie to me. I kept an open mind, and here it is in black and white. There's no judge in the country that's going to be convinced that you paid $2,000 on September the 25th. Ma'am, you just decided to fabricate a document here. That's all you did. Ma'am, talk to some other judge, some other place. You're going to figure out right now how you're going to pay your $2,000. You guys, though, Ms. Bosajor, I don't know what to tell you. You just can't do this and trust people. Were you guys friends? Were you friends?
I dated her brother in high school and we were Facebook friends. And she contacted me via Messenger on a social media ad. And I should have never answered the phone. I really should have. I did all kinds of stuff for her.
You're going to go figure out where you're getting it. Hang on. You're going to go figure out where you're going to get the $2,000 today. Then everybody will be happy. So sit in the back, figure out how you're coming up with $2,000 today.
I don't have $2,000.
Well, you had enough gumption to come in here and lie to me.
I'm not lying.
You're lying to me, ma'am. I see the title.
That's what?
You're lying to me. There's no way. You signed the document, the one I just showed you. It said that you were going to pay $500 payments starting October 1. And you made a payment on October the 2nd that you both initialed, saying you paid $500. Then you paid another $500 on November 5. Then it's blank. If you'd have paid on October 2 and November 5, the car would have been paid off. There's no indication her initialing anything. This is what happens when things are done in cash. Ma'am, I'm making my ruling. And I'm telling you, I don't know what I'm going to do right now going forward. You're not going to come into this courtroom and lie. Well, you just did. Under oath. That's perjury. Perjury. It's one of the easiest calls I've had in the last 17 years. Maybe 31 and a half. You figure out who you're going to call to come and get the money to pay this late. Right now. And then we're going to go from there. I'm going on to another case. Now, I could make you transfer the title over to her because you violated the terms of this purported security agreement. But I don't think that's fair with her. To her. You're going to figure out how you're coming up with $2,000, but you're not going to come in here and lie to me. Jeremy, Kristen, have a seat, you two. Jeremy, Kristen, Antonio, Robertson, 255W8376064.
Morning, Your Honor, Job Trust, here on behalf of the people.
Good morning, Your Honor. Peter Granata, P78413, MIDC counsel for Mr. Robertson.
Robertson, you're late. You knew I was going to do this at 8:30 to not interfere with another judge's docket. You come strolling in at 9:15. Why? It's not good enough. Your name? All right, so this can be a plea to disorderly conduct. There's, the prosecutor is going to move to dismiss the retail fraud, and there's agreed upon restitution of 1146 to Lowe's, correct?
Yes, Your Honor.
And is that correct, Mr. Granata?
Yes, Your Honor.
If you plead to this, possible penalties are up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
Yes.
You are presumed innocent. You need to wear those sunglasses. Do you have some eye issues?
So I mean, this,
Is it an eye issue or you just feel like wearing some?
right, in my system.
If you plead guilty, you're giving up your right to a trial. You're giving up your right to remain silent. You're giving up your right to question their witnesses at a trial. You're giving up your right to bring in your own witnesses, to use the subpoena powers of the court to bring in those witnesses. And a testifier remains silent. If you remain silent, that silence would not be held against you. By pleading guilty, you're giving up all those rights and we won't have a trial. Do you understand that?
Yes.
You agree to plead guilty to this charge.
Yes.
You understand the possible penalties, and that along with it, you're going to pay $1,146 to Lowe's through the court in restitution
Yes.
to the charge disorderly conduct. How do you plead?
Yes.
Were you at 21,000 West Road at Lowe's, May 31 of 25 in Woodhaven?
Yes.
And did you commit the offense of retail fraud by stealing property that was valued at $1,146 that was not recovered?
Yes.
What kind of property was that?
That was right.
I know, but was it toothbrushes? Was it gum? What was it? I mean, come on. I know it was Lowe's property. What kind of lawn equipment? Lawnmowers?
Lower.
What else?
House.
And you walk past the register somehow without paying for those items
Yes.
with the intent to deprive them of that property? Are you on probation or parole?
Yes.
For what? You understand by pleading, were you on probation or parole on May 31 of 25?
Yes.
And that's for CCW?
Yes.
You understand by pleading guilty, this would be deemed a violation of that probation or parole, and that parole or probation could be revoked as the case may be, and you could be incarcerated. You still wish to plead guilty?
Yes.
Anybody force you to plead guilty? Please accept it. Did you guys ever get that, I'm going to accept your plea to disorderly conduct, dismiss the retail fraud, order a pre-sentence report? Was there any indication, counsel, did I ask your appearance since we started on this? Okay. Was there any indication of alcohol or drug use or anything?
No.
I'm going to order a pre-sentence report and a sentencing date.
Was a co-defendant, Your Honor, does not have protection.
I see. All right, give me a sentencing date. Heather, we're going to want to make sure this stays on my docket day. This is an off day. So what would that be, like March the 2nd or something?
Yeah, March 4th, Judge.
March 4th. And we'll do this at
I will
8:30.
be in court March 4th as well.
Okay, March 4th at 8:30 a.m. Okay? You're going to go down the hall, get your notice. Then you're going over to probation where you'll fill out a question. You're going to be interviewed, okay? Wish you well. Good luck.
Mr. Robertson, I'll call you tonight.
Thank you.
Your Honor,
Thank you, Judge.
the lady from Knight's, things back, so paperwork that they said you noticed.
Oh, where's that?
She did,
file?
it was found online, Judge, that she did pay, and she has the
Oh, in the
receipt from
do you have the
Joni.
files or do I have the files? Who has the files?
You have them, Judge.
You recall, right? Oh, here it is. Here.
Come on up here, ma'am. Call Brownstown in here. Is this my Brownstown day?
It is.
Good. All right. I'm going to help you. Next time you're going to be a little bit more diligent, okay? All right. Let's do this. Call in. So just to be clear, she paid 25B 82558 in full, right? $198. Is that true, Heather?
Correct, Judge, and there should be a receipt in the paperwork there that if she
Okay.
handed it to you, or she has it.
Good morning. How are you?
Judge, thank you.
Your appearance?
Township.
So again, she showed up. This is a show cause. She wasn't here. Failure to register rental property. The default was entered. Citation was issued back in April 11, 25. She paid it last night. You have a misdemeanor here. I was telling her she had to go get a lawyer because she's not a lawyer and it's a corporation, as you know, and it's a misdemeanor.
Right, we spoke yesterday about that.
You want to just dismiss this now?
Yeah, they're still not.
Oh, they're not?
I sent to the ordinance officer the inspection report. They even scheduled the re-inspection tomorrow.
Right, so they need the re-inspection to take place before they can.
Okay, good enough. Well, wait a minute. I can't do anything more then. This is what I'm going to do. How long will it take her to do everything the township needs her to do?
Hope if she passes this inspection, it'll be pretty quick.
Well, I know, but when's the inspection going to take? Good. We're going to reschedule this to February 18th. She's going to need, ma'am, you're going to need to hire a lawyer. Now, if you pass inspection and you're willing to dismiss beforehand, that's fine. This is Judge Hessen's case. The civil infraction was my case. That's taken care of. So this is going to be in front of Judge Hessen next week. You're going to go down the hall, get your notice. If you pass inspection tomorrow, talk to Ms. Foley Carter. Maybe she'll dismiss it. Otherwise, you have to have a lawyer, okay? All right? Thank you.
Good judge.
Do you understand everything that's going on?
Yes.
Are you sure?
Yes, I've been trying to coordinate this whole thing with the city and so many emails, and I just really wanted to resolve it.
Well, if you pass the rental inspection tomorrow,
That's
okay? Good luck. Go down the hall, they'll give you a notice. These two did not leave, did they? Both?
I think they're talking.
John James Schaefer. 26B1499998A. B, your name?
John Schaefer.
So you have the right to a lawyer. You're charged with disorderly person, public intox, and resist and obstruct. Do you want a lawyer?
Yes, sir.
We'll set you up with a lawyer, go out in the hallway, and you'll meet with the lawyer, okay? And then either way, you're coming back in front of me.
Yep.
So he's getting a lawyer. Daniels, Brandon Jack Daniels. 26B150144. See, this is Judge Hessen's too, it looks like. Well, at least the ticket says my name. But on the register, it's printing out Judge Hessen. Do you know, is this mine or hers, Heather?
Let me take a look, Judge. Check the date on it.
Sir, your name?
Brandon Daniels.
All right, so you're charged with driving on a suspended. I don't know if it's mine or Judge Hessen's. We're figuring that out.
It
looks like
is yours, Judge.
Okay, so I'm going to just change it on the register here. You have the right to a lawyer if you want one, or I'll arraign you, let you go talk to the prosecutor, whatever you want to do.
I just want to resolve it.
Well, I know, but do you want a lawyer or you want me to explain the penalties and your rights and let you go talk to the prosecutor?
I'm all right.
You waive your right to a lawyer? Is that what you're saying?
Yes, sir.
Okay, it is alleged that you did on January 20 of 26 operate a motor vehicle with a suspended license on Eastern Air King at 9:45 p.m. That is a misdemeanor punishable by up to 500 fines, 93 days jail. Costs are all those 2 points. Do you understand that?
Yes, sir.
And you understand all your rights?
I do.
If you plead guilty, you'll be giving up all those rights and we're not going to have a trial of any kind. Do you understand that?
Yes, sir.
You still wish to waive your right to a lawyer?
Yes, sir.
$500 personal bond, not guilty, pleas entered. You cannot leave the state without the consent of the court or violate a law. Prosecutor must appear in court as directed. You're going to go sit out in the hallway. The Brownstown Township attorney will call you in and she will talk to you and you see if you can resolve it either way, whether it's a plea or an adjournment or dismissal, whatever, you have to come back in the courtroom. Okay? So just go right out in the hallway and they'll set you up. Thank you.
Thank you.
Erica Elizabeth Horvath. 26I-415-206. Thumb failed to appear. Fault judgment entered. For failure to appear, it was scheduled for 9 Is this your only one? You came in here just for one case?
Yes, Your Honor.
All right, well, you're all set. I'm going to go ahead and enter a default judgment. If you don't have any other reason to be here, have a good day. Thank you.
Thank you. You too, Your Honor.
Bye now. We might as well take a recess.
Yeah.
All right. All right, we're gonna give them a date out, Heather, about 4 weeks. Your name?
Brandon Daniels.
We're gonna adjourn this. You guys wanted adjournment for 4 weeks, so we'll adjourn this to March what, Heather?
That will put us to just Brownstown. You're off on the 11th, so that'll put us to the 19th.
19.
I have a question, Your Honor. Does it show on your end the unpaid ticket out of Detroit and what district it is so I can take care of it? All right.
We're gonna see if you got a warrant, first of all. Hang on 1 second. Yeah, you got a May 8, 25, no proof of insurance. So you got to go take care of the no proof of insurance out of the 36th District Court
36th District.
and be sure to pay your clearance.
Okay.
That's a $45 fee in addition, okay?
Yeah.
So go over and take care of that. I think that's what he wants you to do. Go down the hall, get your notice for March 19th at 8:30. Make sure you take care of it by then, though, okay?
Yes.
Good luck.
Thank you.
Thank you. Do you know where those ladies went? Or you-
I'm about to go. I'm gonna go out there and see if they're out there.
Mr. Young?
I'm young.
I think John has to get this guy out.
Raymonte Ronald Young, 25B148921, A and B. And I also have 25W8404568. Good morning. Mr. Young, your name?
Ronnie Young. Good morning, Your Honor.
All right, so let's start with, let's see here. Would we have a 921A? Let me see. He's going to plead to no ops and they're going to dismiss the suspend, true?
Yes.
Is that what you want to do on that file?
Yes, Your Honor.
If you pleaded no ops, possible penalties are up to 100 fines, 90 days jail, costs or all those. Do you understand that?
Yes, Your Honor.
And you're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent, right to a trial by court or jury, right to question their witnesses, right to bring in your own, right to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights and we're not going to have a trial. Do you understand that?
Yes, Your Honor.
All right. To that charge, no valid operator's license on person. How do you plead?
Guilty.
Be operating a motor vehicle in the township of Brownstown on July 10 of 25 on Telegraph near King.
Yes, Your Honor.
You have a valid license on your person.
No, Your Honor.
Are you on probation or parole?
No, Your Honor.
Anybody forced you to plead guilty?
No, Your Honor.
Accepted to that charge, the suspend's dismissed, and on 0456A, there's also going to be a plea to no ops. Take the plea to no ops, dismiss the suspend. But I'm not going to dismiss the disobeyed traffic control device. He's been in default on that. Judgment was entered. Yeah, that would have been defaulted a long time ago, back in November. That's why, because it's in default. Do you still have that showing as paid? is in default, Heather?
Yes, Judge.
So that one, I'll take the plea to no ops. I'll dismiss the suspend, but he's gonna have to pay that one, okay? If you plead to no ops on this other file, the possible penalties are up to 100 fines, 90 days jail, costs or all those. Do you understand that?
Yes, Your Honor.
You understand your rights?
Yes, Your Honor.
To the charge, no valid operator's license on person. How do you plead?
Guilty.
On October 26th of 25, were you operating a motor vehicle in Western Ford Lane and Wood at 2:07 in the morning?
Yes, Your Honor.
Did you have a valid license on your person?
No, Your Honor.
Probation or parole?
No.
Anybody force you to plead guilty?
No, sir.
All right, that plea is accepted. So I got to sentence him on 2 no ops cases, and he's got a default charge on a expired plate from 921B and also on the traffic control device from 456AB. He's not in custody on this, is he?
He's got some other charges in front of Judge Hess, and that's where he got picked up and new charges arose. And that's why he was taken in on Monday. We arraigned him on Monday.
No, I was taking in for the warrants I had from Mr. McNally. They gave me citations for those other charges.
McNally.
Yeah, that's why I'm in jail. That's why I'm in custody, because of your warrant, sir.
Yeah, because I said 15,000, 10%.
Yeah.
When you gonna grow up at any point, and then 1,500, 10% on the other charge. Go, what are you gonna say?
Judge's driving records is not that probably a place where it could be rehabilitated, get a license. I would just ask the court to consider what we thought you're gonna take the hit on the 2 all the victims. You have the points to go along with those. And then it's kind of 3 days in jail.
Anything you'd like to say?
Yes, Your Honor. If you will let me be released, I will. I get paid tomorrow. I just started my job at McDonald's a week ago. I literally get my paycheck on the 12th, and I will literally give you your money by Friday. I'm working hard. I lost everything within the last couple 8 months. I'm not trying to sit here and get sympathy or anything, but I will show you that I'm trying to take everything seriously. I gotta go to work today at 6 o'clock.
Well, stop acting like a fugitive, will you?
I got you, Your Honor.
On this case, 100 fines, 50 costs, 75 victims' rights, $50 justice assessment, 275 or 30 days, credit 3. I'll let you pay this, and that's on both cases. And we're gonna have him released to anyway. And I'm gonna let you pay. I'm gonna do this. I want you to set up another payment hearing for me, Heather. And we're gonna give him a date right now. And he's gonna come in, he's gonna talk to me like a man. All right, that's what we're gonna do. You start saving some money. I'm gonna be very reasonable with you if you come in here and talk to me like a man and quit acting like a little child. Will you do that for me, please?
Yes, Your Honor.
So give him a hearing date on all 4 of these tickets. Payment arrangement date, call it whatever you want. We'll set it up for a week from now.
Okay.
Can we do it, Heather? I'm not going to write on these files. Can we do it just like a week from today?
Okay, you want to do it as a due date, Judge, or as like?
I'm going to set it up because I want those other files out. I don't have the other 2 civil infractions or the 1 civil infraction. And I'm going to cut him a break if he comes in here with some money. Why don't you set it out about 2 weeks? So
That'll put us to the 25th.
Perfect. Let's set this up for the 25th, 2 weeks from today, young man. And
thank you, Your Honor.
And we're going to set it at 8:30 in the morning, and we're going to send it to Matt's Drive. That's where your address is, right?
Yes.
So set these up. I'm not writing on the files, Heather. February the 25th at 8:30. Make sure you send the paperwork down. If there's any question, he's to be released on these 2 now, okay?
Okay, Judge.
And I'll cut you a break, but come with some money. Where is the Ms. Hernandez? Thanks a lot.
Thank you. Thank
And then
you.
does he need to
Where'd
zoom
she
in
go,
on
Ms. Bolson-Joy?
Mr. Haynes?
Were you talking to her?
Oh, see.
Is somebody bringing Ms. Bolson-Joy in
I
here?
asked Will, somebody said she was sitting at the end. I told Will to bring her down.
Please do.
I just, Judge,
Stalin, Moan, Hudson. Which one do you have, Mr.
Raymond Saunders.
Judge, does Mr. Ramani need to go over to Judge Hessens now? I'm not.
I
sure if
don't
he-
know.
That's why I was
I
trying
don't
to
know.
catch Mr. Haynes. I believe he may need to.
Okay, so he's gonna have to go over there now?
Yeah, I believe so.
All right. Make sure Mr. Haynes knows that.
Tell them you need to zoom into Judge Hessens now.
Okay, thank you.
You're welcome.
Moan Hudson, 2-6B150000. Your name? Still on what?
Hudson.
You're charged with possession of tobacco.
What was that? What you're on?
Tobacco.
Yes.
You have the right to a lawyer if you want one. Do you want a lawyer?
I don't have money, but
I'll give you one if you want one.
that's fine.
Okay. We'll set you up with a lawyer. Thank you. Saunders.
I've seen Holland.
Trevone Terrell Saunders, 19M714-639FY.
Morning, Your Honor. Michael A. Carton, B738, Portland, defendant.
Did we, your name?
Trevon Saunders.
All right, counsel, let me check. This is an old case. Where you been? You live out of state?
Yeah, I was incarcerated in West Virginia and Pennsylvania.
Nice. So we have a possession with intent to deliver less than 50 grams of fentanyl from 2019. For purposes of arraignment, how does he wish to proceed?
Your Honor, thank you with reading.
All right, sir, I'm going to advise you of your rights. You have the right to remain silent. You do not have to say anything. If you say something in or out of court, whether orally or in writing, it can be used against you. You have the right to a probable cause conference within 14 days. You have the right to a preliminary examination within 7 days thereafter. Again, you have the right to remain silent. If you choose to submit the law questioning with law enforcement officials, and you don't have to do that, then I do want you to understand that you'd be entitled to a lawyer at that questioning as well. Your probable cause conference, you'll be in front of Judge Hessen, will be February 24th at 9:15. And the preliminary exam will be March the 3rd at 11:30. Okay? Do you understand that?
Yes, sir.
So we're gonna have you fill out a petition for a court-appointed lawyer going forward. I'll listen to whatever you have to say, counsel.
Your Honor, as my client did mention, he has been incarcerated in Pennsylvania and West Virginia from 2020 up until the very end of 2025. He is currently though staying in Detroit with his mother, 3250 3rd Street. I did write his
32, wait a minute, you wrote it down somewhere?
Well, I'll give you 3250 3rd Street,
Okay,
Detroit.
okay.
But I did write his current mailing address, which is in Pennsylvania on the ROA.
3250 3rd, is that 3RD or THIRD Street?
THIRD.
And you have that zip?
I think it's 48226. So he's staying with his mother. He can stay with her until whenever, until however long he needs, so this case gets resolved.
Does he work?
Until
Yeah, do you work?
No, I'm at CDO lab. 3 weeks exactly left.
Where was he picked up at? Do you know?
Shorey, in Shorey, I was at the gas station. I was driving my car, came up here and they pulled me over and said I had a warrant. But I thought it was clear, so.
Your Honor, he does have a valid driver's license and insurance to be able to get here from staying with his mother in Detroit. Also has 4 young dependents that he helps take care of.
He had to know about this warrant. He didn't surrender him. 100,000, 10%. You cannot leave the state without the consent of the court. Cannot violate any law or ordinance. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. This is the state police, so we're going to have to get on this and get them to get him or what have you, John. So make sure they take care of that. And also, I want to check and see if he was ever printed on this case. I don't believe so. And you weren't printed, so also you have to be printed and photographed. So we'll have to tell them when we call over to the state to have them get them, okay? 100,000, 10%. You're gonna have to post $10,000. No
The
matter.
state trooper is here in the.
Oh, he is?
Yes, sir.
Where is he? Oh, I'm sorry. I
Can
didn't
I have him chime in on bond?
chime in on bond. You want to come up here. What, you want a lesser bond than that? Is that what?
100,000, 10%?
You haven't been here. Come on. Your name?
Detective Sergeant Mark Lambert.
Did you want to say something on bond?
Yes, he has been incarcerated as an overcharge. And me and him had conversations and I did it. Off the record.
I see. Why don't you and the defense lawyer approach? Come on up here. Yes. So you want the personal bond? Yes. Go ahead. All right, so you want a different bond. Tell me what you're asking me for, trooper.
I said, since the duration and conversations, I wouldn't mind having a personal bond.
All right. 100,000 PR. Make sure you show up. You understand that?
100%, sir.
All right, 100,000 PR, those are the terms, but he's gonna have to get printed today too,
I
okay?
can take it to post.
Thank you very much. You'll be released. Good luck. Thanks, thanks. Is she coming down, Ms. Hernandez?
He said he yelled for her twice. She didn't answer. He thinks she might have left.
Good morning, Judge.
Good morning. Recalling Leslie Bozajor versus Cynthia Hernandez, 2504922. Your name again?
Possibly both of you.
I'm not sure what I want to do. What, do you want the car back?
Sure. We can resell it. Even if it's damaged.
Who does she think she is leaving like that?
She's not somebody I thought I don't know who she is, Your Honor.
You got to be careful in the future.
She knew my husband had just passed away and I was living alone and vulnerable. And I think she just took advantage of my,
Oh, I don't know what. Jennifer,
Yes, Judge.
do me a favor, call Ms. Hernandez. Tell her I expect her to be back up here in 10 minutes. Leave her a message. If
I can
not,
see if there was a phone number provided by plaintiff.
I'm just not sure what you want to do. You made a lot of mistakes here. You signed the title over when you didn't have the money. You didn't list yourself on the title as a secured party. You took cash. You didn't take it. I mean,
I came to your civil department to find out what I should do.
well, they can't give you
No,
advice.
they give me a number to a lawyer and that's what it's supposed to.
Well, I don't want to know what your lawyer told you. And I don't want to know what you told
So
your
that's how
lawyer.
I filled out the papers.
Well, it's fine. When I looked at this, you do in essence have a security agreement. But this is unique because like if you went to a dealership and you got a loan, the bank's name is going to be on there as a secured party. Your name is not on the title as a secured party. Do you know if she works?
No, she's on disability, I believe. She gets $1,000 a month plus food stamps, and that's why she's living at the towers, because it's rent adjusted. You only wanted to make $250 payments for my car, but I told her no, that would take a year for you to pay it off. Yeah, no, I told her you said you have to make $500 payments. And that garbage she wrote in that paper she gave.
Ma'am, I'm not, I've already decided that. You don't need, we don't need to.
Those are lies.
We don't need to, I said that 6 times to her. I know, we don't need to revisit that. I'm trying to think of how I can help you. Ma'am, I said 6 times. Anybody listening would have listened and understood that I was calling her a liar. Okay? I mean, there's no question about it. I don't know how stupid she thinks I am. I'm just trying to figure out how I can help you at this point. You got somebody with a title, somebody's got no money, somebody's on disability. They don't have a job where you can garnish wages. Even if I give you a judgment, you got nothing.
She's on probation.
It doesn't matter. That's wholly different. I'm not shocked by that. Is she in front of me on that?
No, first district court.
Yeah. I want to think about this. I got to think about this. I don't know how I'm going to handle it, to be honest with you. That's going to be best for you.
Whoever's easiest to resolve it, so we can put it behind me.
Yeah, you gotta next time talk to lawyers before you do these things, okay?
Yes, yeah.
I feel like going to the Wayne County Prosecutor's Office over this one. That's how certain I am that perjury charges should be filed. I need a week to think about it, okay? Reschedule this for hearing and I'll figure out what I'm gonna do by next week, Jennifer. This is kind of a curveball, so we're gonna give you a date down the hall, mail it to Ms. Hernandez too.
Okay.
I don't know, I might have you. I just gotta think about it, I'm sorry. All right, set it up for next week sometime, Jen. Oh,
Okay.
you know, it's gotta be at least Wednesday though, right?
Right, because we got to give 7 days.
Exactly.
You
Okay.
have a couple landlord tenant things in the afternoon next Wednesday that you
That's
had
fine.
set. Okay,
That's fine. Thank
we'll do it 1
But just
o'clock
remember, next Wednesday, I've got sobriety period starting at
at
3.
3:30. Yeah, or 3 o'clock. Yeah.
Right, thanks.
She wants to see her attorney. She just wants to see the prosecutor. She wants to give the Brownstown prosecutor.
Okay, so you're gonna show up next week. She'll give you a notice down the hall, okay? I'll come up with something. I'll think about something, okay? No problem. Stellon Loan Hudson, 26B150000. Your name?
Yes, the one with it.
He tells me you no longer want a lawyer, right?
Yes, because I didn't know that I actually had an option.
No, it's okay. So you waive your right to a lawyer. Yes?
Yes, I don't want to wait.
You're charged with possession of tobacco as an underage person. You were only 20. How old were you at that time? 19 on Sibley near Dixon, Brownstown at 1:32 in the morning on November 10. That is a misdemeanor punishable by up to 100 fines, 90 days jail costs for all those. You understand that? And you understand all your rights? You read an advice of rights, right?
Not really.
Why not? Sit down and read the rights, okay? And then I'll explain. John, do you?
Oh, yes. Oh, yeah. I read that paper.
Okay, you understand the rights?
Yeah.
If you plead guilty, you'll be giving up all those rights and we're not going to have a trial. Do you understand that?
Yes.
I'm entering a not guilty plea. I'm giving you $100 personal bond. I'm sending you to the prosecutor. You see if you can work it out. And either way, you're coming back in front of me, okay?
Have a seat in the hall.
Do you understand? Come on back up here. You're looking funny at me. What do you mean? I'm entering a not guilty plea. The prosecutor has to decide with you. He's going to talk to you. She's going to talk to you. She's going to offer you something probably.
I'm sorry. I didn't know.
That's okay. If you don't like what she's offering you, you come in here. I'll set it for another court date and we'll go from there. And if you want a trial, ultimately, I'll give you a trial. Okay, but you're probably going to resolve it with her. Okay, she's not going to be unreasonable. I wish you'd quit smoking, but that's neither here nor there. John James Schaefer, 26B14999, 8A and B.
Mr. Schaefer.
Mr. Schaefer, your name?
John Schaefer.
All right. Does he stand mute, wait, formal rating?
Yes.
Resist and obstruct and disorderly public intox. And then, so I'm entering a not guilty plea.
I'm asking for adjourn the judge for discovery.
$500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. I'm going to go ahead in order that you not purchase, possess, or consume alcohol or illegal drugs. Okay, sir?
Yes, Your Honor.
No alcohol, no marijuana, no illegal drugs. Just wait 1 second. And then you can ask a question. Just let me fill this out for you, okay?
Yes, sir.
What's your question now?
He has a medical marijuana.
Well, I'm not going to prohibit you from using marijuana if you have a medical marijuana card, but you have to have proof of that. It has to be valid. I believe, just listen. I'm not going to violate you if you're using medical marijuana so long as you have a valid medical marijuana card, which you seem to be reaching for, but I'll give you a court date and we'll go from there, okay?
Yes, sir.
Give me a date out 4 weeks if you would, Heather, about.
Judge, that'll put us to March 19th. We do 9/15.
At 9:15, okay?
Yes,
So
sir.
you go down and get your notice. If you want a lawyer going forward, you're gonna need to fill out a petition for one, all right? Okay, I wish you well. Good luck. Thank you. Funchess. Kimura Funchess.
She's on Zoom. Judge.
Kimura Rain Funchess, 25B1499661A and B. Name, ma'am, your name?
Kimura Funches.
Yeah, I can't adjourn it much longer. You're gonna have to clear these, okay?
Okay.
Why is she showing up today? Wasn't it scheduled for tomorrow, Heather?
She was on our docket today at 9:15, Judge.
Okay.
Judge, can we get a date past March 6th? She need to get her license on March 6th.
Is this gonna be the last adjournment?
Yes.
All right, give me the first date after March the 6th.
For Brownstown.
Yeah.
March 19th, is it?
March 19th is the earliest date, huh?
Yes, because you are not here on the 11th.
Okay, what time we doing?
9:15.
The only problem is I won't adjourn it to that, okay?
No, hopefully we'll have a resolution at that.
Good enough. March 19th, ma'am.
Okay,
March 19th at 9:15. Okay, no more adjournments, all right?
yes, Your Honor.
Okay, good luck. Thank you. Brian Kenny,
Good morning, Judge.
Bryant Allen Kenny the third, 25B148-6464.
My name is Jeff, and I can get the current up, Mr. Kenny, you can stick it for me.
Any the third?
If you have a resolution in this matter, we got some points about the,
She's gonna plead the disorderly under,
under item.
all right. If you plead to that, the possible penalties are up to 500 fines. I'll dismiss the original charge. I'll take it under HIDA. Do you understand that?
Yes.
If you comply at the end of the probationary period, the case will be dismissed. Do you understand that? Did he sign an advice of rights?
Yes, there should be one like that, so in files.
Did you sign an advice of rights today?
Today? No.
Okay, you guys are really gonna help me if you can have these rights from Sunday.
That's right.
Okay, here you go. Sadie, hand that to Mr. Leek, if you would, please. Thank you.
That's.
Folks, what do you have? You have a case?
No, we.
You just watch it?
Water.
Okay, okay. What do you have, sir? What's your name?
For mail hour. How soon? No, go down the hall, grab your notice, see sure you're on that. Okay. Right at the clerk's window.
Thank you, sir.
Okay, I see. Do I have a resist hinder and obstruct? Sadie, talk to John about finding this file when he comes back. This Ramel Howard, he's on for 9:30. Second page, second from the bottom.
That's already, Mr. Chairman.
Okay. Recalling Brian Allen Kenny, 25B148-464. Sir, have you now signed the advice of rights?
Yes.
Did you read it and understand it?
Yes.
When you plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that? I can't hear you.
Yes.
You still wish to plead guilty
Yes.
to the charge disorderly conduct? How do you plead?
Yes.
On May 25th of 25 at 11:37 PM, were you at South Glen Boulevard? Yeah, you need to keep your voice up. At or near 19712 South Glen Boulevard in Brownstown.
Yes.
You have to talk to the mics.
Yes, Your Honor.
And what did you do that makes you guilty of disorderly? Did you expose your buttocks to somebody?
Yes, sir.
Why would you do that?
I don't have a good reason.
Judge, at the time, his current girlfriend was seeing someone else. He was upset. He confronted them. There was a verbal back and forth and he ultimately exposed them.
Was he under the influence?
No,
Are you on probation or parole? Anybody forced you to plead guilty? Please, why you been playing games? You came in on this on August 4th and you walked out before seeing me or the attorney.
I was having a really bad day and I don't really have a good reason as to why I left.
All right, I'm going to accept your plea. You're not on probation or parole.
No.
Correct?
Yes, correct.
All right, and I'm going to order a pre-sentence report. And we're going to give you a sentence date in about a month, Heather. So this is Brownstown. We can make it 8:30, whatever date. I don't know. Is it March 19th again?
That's correct, Judge.
Or do you think we can get this one done before I go? What about the 25th?
We can do the 25th. That's
Yeah,
2
let's-
weeks, yeah.
Yeah, let's do February 25th at 8:30, okay?
Okay.
All right, thank you. Go down the hall, get your notice, go over to probation, and you'll be interviewed, okay?
Thank you.
Good luck.
Do that and we go to 15 to 12.
Thanks. We have Bo's in your file, Jennifer Weissman. Ugh. Everybody stay seated. I'll be back in a minute, okay?
Sean Bowers, on position name.
Sean Bauer.
Thank you, sir. And of course, Mr. Bowers here for sentencing. We've reviewed all the reports. There are no factual corrections. Recommendation looks appropriate. I'm asking her to follow it. He's worked very hard on his sobriety. He's very proud of that. I believe this reflects that. He can pay all of his fines and costs this morning.
All right. Sir, is there anything you'd like to tell the court before I do impose sentence?
No, Your Honor.
The court acknowledges this is not a serious misdemeanor as defined by statute, however, does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of individual counseling, attendance at AA meetings, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance with recommended treatment. Therefore, the sentence of the court will place you on probation for a period of 18 months. You're to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $540 probation oversight fees. You can pay that today, sir.
Or you'd like to pay all the fines and costs. You want to do the probation oversight fees later?
Yeah, I don't have the probation fees.
So you can pay the fines and costs today.
Exactly.
Yes.
And then when can you pay the probation oversight fees?
You have a time frame in which you can pay those?
28 days when I get my next.
Where the? Nobody says to me 28 days. Unless you're thinking
I'll
football.
have to calculate.
Is it? No, it's okay. So you need a month.
It was March 11th is when I get my next severance.
He was actually calculating days.
Yeah, it's good for you.
No, I like it. He was gonna do 28 days. He knew February only had so many days. And he's right. That's how many days it is. Pay by March 31st, 2026. Will that work for you, sir?
Sure.
All right, thank you. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. Attend individual counseling with status reports to probation. Attend 2 AA meetings per week with monthly verification to probation. Provide proof of victims' impact panel attendance to probation. Continue to scram tether for an additional 30 days in lieu of 4 days in jail. I'll order 93 days in jail. Credit 1, the balance is suspended. All right, thank you, sir.
Thank you.
Good luck to you. Court calls case People versus Michael DeWitt.
Morning again, Your Honor. Dan Garrett on behalf of Michael DeWitt stepping forward. Michael.
Michael DeWitt.
Thank you.
Your Honor, we're here for sentencing. I understand there may be a victim statement today.
All right, very good. Where does he have a seat there?
Your Honor, the victim in this case is Joshua Wade.
All right.
Hello, Your Honor. My name is Joshua Wade. I'm the victim in the case. Your Honor, I provide the court a written statement, but I wanted to provide a brief verbal statement in summary. It is my understanding that Mr. DeWitt has shown true remorse over this incident and is prepared to make full restitution. I'm also under the understanding that he has no prior criminal record. I support the terms of the plea agreement as I understand them, namely a period of probation, anger management, and with a delayed and restitution with a delayed sentence so that he does not end up with a permanent criminal record. Mr. DeWitt's Actions impacted me in several ways that I mentioned in my written statement. However, I want to call attention to the impact on both myself and Mr. DeWitt that did not occur, but could easily have. In Michigan, more than 1 in 10 adults holds a concealed pistol license. We are ordinary citizens who go about our daily business much the same as everyone. We don't look any different, and yet we carry with us the means to effectively defend ourselves from grave danger. On the day of Mr. DeWitt's crime, I was carrying a SIG P226 9mm with 15 rounds and 1 in the chamber. As he approached my vehicle and confronted me, my primary thought was to ignore his provocations so that I would not be placed in a situation where I may need to defend myself with force. When I parked and Mr. DeWitt remained in the area, I went inside rather than risk a physical altercation that could have had tragic results. As you know, Your Honor, Michigan has no duty to retreat. However, I chose to retreat from the area while Mr. DeWitt maliciously damaged my vehicle rather than remain and potentially becoming involved in a situation that could have been tragic for Mr. DeWitt and for all those who love him. I say this not to intimidate or threaten Mr. DeWitt, but rather because it is my sincere hope that he learns from this event the importance of moderating his temper. Thank you, Your Honor.
May I proceed, Your Honor?
Yes, you may.
Your Honor, Mr. DeWitt and I have reviewed all the reports. They are accurate. I believe the recommendation is appropriate. He's glad to see that the prosecutor's deferred has been recommended. He's asking Your Honor to follow that. Just a background, Mr. DeWitt is 59, soon to be 60 years old, never been in trouble a day of his life. He was undergoing some pretty serious health concerns at the time and just lost his temper. We've all had our bad moments. He's very remorseful for his conduct. He's ready to pay all restitution and fines this morning.
DeWitt, anything you want to tell the court before I impose sentence?
To assure the court that I'm remorseful for my actions. I apologize, and it won't happen again.
Sentence of the court, I'm going to place you on 6 months prosecutor deferred sentence. You are to pay $555 fines and court costs, $180 probation oversight fees, $868 restitution to Joshua Wade payable through the court. You can pay that all today.
Yes, sir.
All right. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete an anger management program as directed by probation. You're to have no contact with Joshua Wade directly or indirectly. There is to be no assault or threatening or intimidating behavior on your part. I'll set your review hearing that's to be held August 12, 2026, 9 a.m. I will order 365 days in jail that is suspended. All right.
Does restitution have to be paid in any certain amount of way? I never remember that. Cash
It
only?
needs to be cash.
Okay, sounds good. Didn't come back and do that.
I have it.
You have cash. Sounds good, Your Honor.
I think Ms. Polero probably told it.
That's probably true.
She did.
Sounds good, Your Honor.
Thank you, sir. Court calls the case, People versus Jamonte Love. Or not. Jamonte Love.
Yes, I'm here. On
Oh,
Zoom.
he's in Zoom.
And so was the attorney. I'm probably.
Good morning, Your Honor. Shauna Bassi on behalf of Jamonte Love.
Thank you. Mr. Love, state your name.
Jamonte Love.
All right. State time set for sentencing. Counsel, you may proceed.
Good morning, Your Honor. We've had a chance to look over the pre-sentence investigation report, and there's no corrections to make on that report. But Your Honor, we are asking, Mr. Love is, he's a full-time coach. He works full-time with Ford. He's very busy with his children in sports. And he also has a landscaping business that he owns. The sober link has been kind of difficult for him to manage with his schedule, his timing, the timings. He's wondering if he could maybe submit to random ETG testing in lieu of that. Also, for the probation sentence, Ms. Pilara did point out that this sentence or this charge is not it's not a serious misdemeanor, but she believed that there's reasonable grounds to depart from it. I'm asking the court if they could consider reducing it maybe to 12 months probation.
Your Honor,
Jen,
Teresa Claire on behalf of probation, I would ask the court to follow the recommendation as put forth. The underlying charge did involve having an occupant less than 16 in the vehicle.
Yes.
I do recognize that he did plead to the operate while intoxicated. However, probation feels that the recommendation is appropriate.
Mr. Love, anything you want to tell the court before I impose sentence?
One thing I would like to say is about me being a 39-year-old, I have never been in trouble. I'm an active member in the community for over 20 years. I've been a football coach. I'm actually a head football coach. I have my own business. I worked for Ford Motor Company for almost 20 years. And I get that that I made a mistake. I take full accountability, and it will never happen again. And it was just a bad mistake. And right now, I'm just trying to get this over with, but I apologize for everything I've done.
The court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. Particularly the alcohol screening and assessment identifies the benefit of outpatient treatment, attendance at AA meetings, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. It is therefore the sentence of the court. I am going to place you on probation for a period of 18 months. You are to pay $855 fines and cost, $100 prosecution recovery costs, $100 police agency recovery costs, and $540 probation oversight fees. When can that be paid?
I can have everything paid by Saturday, March 14th, if that's possible.
Pay everything by March 16th, 2026. There is to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete outpatient treatment, including all recommended aftercare with status reports to probation. You are to attend one AA meeting per week with monthly verification to probation. You're to provide proof of the victim's impact panel attendance to probation. Counsel, I am going to continue the sober link unless he would like to do 4 days in jail. I'll give him that option if that's what he wants to do.
We've actually discussed that, Your Honor, and I believe that he would rather do that instead of having to worry about messing up again with the sober link. He's just.
So he wants to do 4 days in jail?
Mr. Love?
Yes, but only if it's possible, if you could grant it to next weekend.
Well, I'm going to set the time. If you're going to do the 4 days in jail, I set the time. You don't get to run the show.
Because he's set to work next weekend, Your Honor, and he doesn't want to get in trouble at work.
This weekend.
Or this weekend. Because Ford Motor Company has a strict policy with her. But he can do it next weekend.
Yes, I'll take
And
it.
if I order it this weekend, what's he going to do?
I mean, I will have to do what you said. I'll just have to try to figure something out with work, but I will probably get disciplined at work for missing. So I'm kind of in a hard situation where with work or with you, but the sober link, another 45 days on it. I just don't want to jeopardize myself with missing or being late taking a test.
Your Honor, probation wouldn't be opposed to him going on a scram tether, then he wouldn't have to worry about missing any testing.
But that's more
Does he
money.
want to do that, counsel?
That's more money that I would have to come out of pocket by keeping that on as a tether.
Sir, none of this is going to be pleasant. I don't think it's designed to be pleasant. You're gonna have to make hard choices.
I understand that. I'll just do the 4 days.
Four days, Washtenaw County Jail. Who's to report to the Washtenaw County Jail tomorrow morning, 8 a.m. What, the 12th? It's February 12th, 2026, 8 a.m. I'll order 93 days in jail. Credit for the time that he served. The balance is suspended. Thank you.
Thank you, Your Honor.
Court calls the case, People versus Taylor Buyer.
Please, this honorable court, Brandon Bird on behalf of Taylor Buyer. Mr. Buyer, can you please state your full name for the record?
Taylor Martin Bird.
I respect.
Go ahead.
No additions, deletions, corrections. Did get a chance to review the pre-sentence investigation report of my client, Your Honor. I do want to just state a couple things that for number 8, on page 2, regarding the prior arrests and convictions, my client is getting those warrants handled. With Livingston County, he had to show proof of incarceration, in which he gave that proof of incarceration to Livingston, and he also plans on going to 34th district today to handle that matter. Okay. We're just asking to follow the recommendation, Your Honor.
Is there anything you want to say before I impose sentence?
No, Your Honor.
All right. $125 statutory fees will apply the bond of $90. At some point, he'll have to pay the balance, but we'll apply the bond. I'll order 61 days in jail, credit 61 served. You're all set with me.
Thank you, Your Honor.
You're welcome, sir.
Thank you.
Take care. Have a wonderful day.
You just say. What, Mr. Bird?
Thank you, Your Honor.
What are you?
I said, thank you.
You want me to change my mind?
So thank
Is
you.
that what
We're
you, no,
very
you're trying to get me to change.
grateful.
You are trying to get me to change my mind.
Not at all. Not at all.
And Mr. Byers, like, he's like, you know, shut up. No. All right. Take care.
Thank you. Take care. Have a wonderful day.
Court calls the case, People versus Carlos Mack.
Yes, Your Honor. Brandon Bird on behalf of Carlos Mack. Mr. Mack, can you please state your full name for the record?
Carlos Mack. All right. Why didn't he do his alcohol screening and assessment?
My client indicated to us that he called the lady at Von Schwartz. She did send an email to him on the phone, but he had to pay him to take the class.
He had to what?
He had to pay him to take the class.
Yeah.
But he's been in jail for a while, Your Honor, and it was just a little difficulty coming up with the money. But he does have the money together. He does plan on getting the classes taken. We're just asking this honorable court's grace to allow him to finish the class by March 11th, please.
Grace.
Grace and mercy, Your Honor.
Oh,
grace and mercy.
Mercy. Grace and mercy.
Grace and mercy.
So he wants two things. Wow.
Humbly, Your Honor.
So you'll be able to get the assessment done. Yes, sir. I So got we my can- paperwork together. Yes, sir. All right. I apologize. I'll re-refer to defendant to Von Schwartz for alcohol screening assessment. You need to pay a $75 re-referral fee. When can you pay that? As soon as possible. I'm just trying to get.
Okay. As soon as possible. You gotta get this done.
That's how we got into this problem now. Can I say by March, by the end of March? Pardon?
$75.
$75?
Right.
When, what, can I get 2 weeks? I'm sorry. I apologize. So you can pay it by the end of February? Yeah. Can I get the 1 week, first week of March, just in case? I just want to be on the safe side. You've been talking to Mr. Bird too much. When can you pay it? Can I get the first? Here's what you need to do. I'm just gonna make it easy. Pay it by March 10th. All right, thank you. So if you come to sentencing and haven't paid it, we're gonna have a problem. Okay? Thank you. I appreciate that.
You still gotta pay for the class.
Yeah, yes, sir. Yes, sir. And I got 75, what do I pay that at? The court. All right. Yeah, at the window. We're more than happy to take your money. Thank you. All right, and then I'll adjourn your sentencing to March 11th, 2026, 9 a.m.
Thank you, John. You and your Honorable Court have a great day.
You do the same. That's it for you?
That's it for me today.
You caused so much trouble just in those. Take care. Court calls the case, People versus Nicholas Smith.
Good morning, Your Honor. Robin Kennedy, on behalf of Mr. Smith, who's present via Zoom. Mr. Smith, please state your name for the record.
Yes, Nicholas Smith. All right. So he's seeking to get into the 54A court.
Yes.
So are we expecting the MOU or?
Your Honor, Teresa Claire on behalf of probation. I contacted 54A to see where he was or whether they've accepted him. They didn't know about him. So I don't know if there was a disconnect. So I'm not sure where he is in that process, and maybe counsel can enlighten the court with that. So at this time, I'm just asking that it be adjourned. So whatever intake process with 54A that needs to happen so we can have that completed form for sentencing on March 11th.
Okay, counsel, is he in? I mean, what's going on with him?
He has completed the intake process. He has been accepted. They provided us with the MOU transfer. So now we're back in contact with Brendan, who is the individual that we would previously been in contact with, and said that he has been accepted. We've sent the MOU over to their office in hopes that they will sign it, and then perhaps we can get it to probation and have this court sign it. But it's my understanding that they can't officially accept him until the transfer paperwork is
exactly.
But they did have a space for him. I was notified that he is eligible and that they're happy to take him. So we just have to get that last piece tied up. I think March 11th, we should certainly have that done.
Somebody wants to go in and get help and we make it more difficult. That's an amazing concept. Anyway, I'll adjourn his sentencing to March 11th, 2026, 9 a.m. All right.
Thank you, Your Honor.
Thank you, guys. You're welcome, sir. Court calls the case, People versus Christopher Middleton.
Good morning, Your Honor. In fact, on behalf of Christopher Middleton, please state your name for the record.
Christopher J. Middleton.
Thank you.
This is the day and time for sentencing. We have received the pre-sentence report. I did send a copy to Mr. Middleton for his review. I have no addition, deletion, or correction, and we find the recommendations fair.
All right. Yes, we do. Anything either of you'd like to say before I do impose sentence?
It's been a pleasure working with Mr. Middleton.
Really? No, go ahead.
Just don't ask him if it was a pleasure with me. In my interactions with him, I've been able to glean a lot of information. He's heavily involved in his community and in his church. He was really forthcoming with what happened that day. And prior to this, he had completed a firearm safety course, which I did submit the certificate to Ms. Pilara, I'm sorry, not prior to this incident, after this incident, he had completed it, and I did submit the certificate. He's very mindful and thoughtful and critically thinking about what happened. And I have no reason to believe we would ever see him in court on this side again, unless he's in support of someone.
That's correct. All right. Is there anything specifically you want to say?
I'd like to apologize to the court and to the individuals involved on September 9th, 2025. And I will continue to be involved in my community and my church and to grow from what happened and to learn, educate other people about what happened. So they know better how to handle themselves in a situation. So it can be done a different way. So things don't end up like they do today. So,
gotcha.
Thank you.
Sentence of the court, place the defendant on 6 months probation. $555 fines and costs, $180 probation oversight fees. When can that be paid?
Today.
Thank you, sir. Pay that today. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete a gun safety class as directed by probation, but my understanding is that's complete. There's to be no assaultive, threatening, or intimidating behavior. You're not to possess any weapons, firearms, or ammunition, or anything fashioned to be a weapon. I'll order 365 days in jail. Credit to the balance is suspended. All right. Thank you, sir.
Thank you.
Thank you, Your Honor.
The court does call the case of the people versus Candace Brooks.
Ron Brown appearing on behalf of Candace Brooks.
Morning.
Morning. State your name.
Candace Brooks.
Mr. Brown.
Your Honor, I'd ask the court to follow the recommendation, fines and court costs.
All right, I'd only indicate so that she can go over and take care of it. She's got a warrant out of 14-2.
I talked to her yesterday. She told me she would submit a warrant recall or contact the court regarding that warrant.
Okay, so you're aware of that? So.
Yes, I am.
All right, ma'am, anything you want to say before I impose sentence?
No, Your Honor.
Sentence of the court, $480 fines and cost. When can you get that paid? Why is she appearing by?
Can we set out for May?
So when can you pay that?
Can we set out for May, Your Honor?
May?
Yes.
You have nothing today to pay on this?
I can do 50 today. It's for groceries, but
Good morning. Again, your name. So they're going to have you plead to a civil infraction of minor in possession of tobacco, okay?
Yeah.
Civil infraction, they're going to dismiss the misdemeanor, okay?
Okay.
All right, to that charge, responsible, minor in possession of tobacco is civil infraction, responsible or not responsible?
It's fine.
Okay, I'll accept the plea, dismiss the misdemeanor. 125 is your total, okay? Can you go down the hall and pay that now?
Yes, I can pay that around today.
Okay, I'll just say pay by 4 p.m., okay?
Put 7.
I'm sorry?
So my check comes at different times. Meaning I won't be able to pay it till later on today.
Okay, all right, I'll tell you what, I'll just give you till tomorrow. How's that? Pay 0 now and the rest by tomorrow, okay? Good luck. All right. Howard. Donnell Libertis Howard. Junior, 25W838526. Your name, sir?
male or his power.
All right, you are charged with a violation of probation. It is alleged that you failed to complete 1 day on the court work program, failed to pay fines and costs as ordered, and failed to provide proof of completing 8 hours of community service by November 15th. Those are the 3 counts. If you plead guilty, if you're found guilty, you could get 15 days. Your 771 status could be revoked and the conviction would remain on your record. I'm just saying those are the possibilities. Do you understand that?
Yes.
Did you sign, read, and understand an advice of rights form here today?
Yes.
If you plead guilty, you're giving up all those rights, and we're not going to have a hearing. Do you understand that? All right. You have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer?
No.
I'm going to need Jessica. To the charge, you failed to complete 1 day on the court work program. How do you plead?
I made it there, but
Not guilty or guilty? You plead not guilty?
Wait, say it again. What was the question? I'm sorry.
To the charge that you failed to complete 1 day on the court work program, how do you plead?
Yes.
To the charge that you failed to pay fines and costs as ordered, how do you plead?
Yes.
To the charge you failed to provide proof of completing 8 hours of community service by November 15th of 25, how do you plead?
Yes.
Did you fail to provide proof of completing your 8 hours of community service by November 15th of 25?
Yeah, I started.
Just answer my questions right now.
Yes.
Did you fail to complete 1 day on the court work program?
Yes.
Did you fail to pay your fines and costs as ordered? Anybody force you to plead guilty?
No.
I can't hear you.
No.
I'll accept your plea. Count 1, failure to attend 1 day on the court work program. Count 2, failure to complete or failure to pay your fines and costs as ordered. Count 3, failure to complete 8 hours of community service by November 15th. What's the problem? Your name?
Just hold on.
What's the problem? You're not doing any of this. I ordered this back in September. This is October 1st, rather. This is mid-February. Why haven't you done this yet?
I just haven't had a lot going on.
Like what?
It's just been a lot of hard shit, but
Well, tell me. I don't know what you mean. You got to be more specific.
like with the work detail, like I had have been having car problems. My car had broke down and I had caught an Uber all the way down to the down here, but it was like 5 minutes late and they were very strict on the time. So he told me I had to leave. And that was like $125. Like 100, yeah, like 125 there and back. So, I started the community service. That was last week. So I told them all together it was 14 hours because I was going to do the extra hours for this whole meeting. And on the money.
Are you working?
Not at the moment.
Why not?
It's like I applied for a new job, but
when did you last work?
I have been working with my father, so like the last time I worked was maybe like last week.
How many hours did you work last week?
It just be like jobs, like certain jobs.
Just answer. I'm having a hard time understanding what you're saying too. You're not working.
No,
you don't. What's that?
Not at the moment.
Why not? How old are you?
27.
Where do you live? With who?
I live with my grandmother. But I work with my father, so. Yeah, but I applied for another job, but when I applied at the 90, this has showed up.
Where?
It was it's called WSHH.
Oh.
It's like
I don't know what that means. What's the name of the what kind of company?
it's like they do like referees all around the state.
Referees?
Yeah, like referee all around the state.
Refereeing what?
Like kids basketball, high school basketball, soccer, lacrosse. There's a lot of different types of sports. But it pays well. So
listen to me. Did you graduate?
Yes.
Okay. I don't know how to say this. There's no reason for a guy like you that's 27 years old. You don't have any kids, right?
No.
You're not married, right? Why in the world aren't you working a lot? I mean, you're only gonna have one chance to do this thing. You ever think you might be able to retire? I mean, you're not gonna retire if you're working every other job every other week and making $122 and you have to take an Uber because you don't have a car, or your car breaks down and you can't fix it because you don't have the money. Get a job. You'll feel so much better about yourself. You know what I mean?
Yeah.
Judge, if I could, he was sentenced to 6 months under the delayed sentence under 771. He's set to be discharged March 18th of next month. And I tried to give him time on this, but we're running out of time at this point.
I told you to come and talk to me if you didn't have the money. I told you to pay $100 bi-weekly starting October 24th. The total fines and costs were $520. You now owe $525. Did you bother to come and talk to me or call the court and go on Zoom and say, hey, can I talk to the judge? I need an extension. If you're not working and you don't have the money, why in the world couldn't you get 8 hours of community service completed by November 15th? Now, I don't want to cast aspersions here, but when I see the whole picture, you do what you want. It's your life. Okay. Whether you become Rockefeller or you live in poverty, it's no skin off of my neck. But when I look at somebody that can't do 8 hours of community service, is irresponsible enough to not call the judge, though the judge has offered to come and talk to him, it just tells me that you're irresponsible. And I'll let you decide whether or not you're lazy. It's up to you. You're going to end up with this conviction on your records. What's going to happen? I think I remember you telling me at the sentencing you were working with your dad in odd jobs, weren't you?
True.
Who's paying for you? Do you pay rent to your grandma?
Yeah, I help him.
I know, but how much do you pay her? You don't pay her anything, do you?
No, I do actually.
Well, how much? If you gotta hesitate, like I could tell you how much my mortgage payment is.
$200 a week.
You give her $800 a month?
Correct.
Where are you getting $200 a week at?
I told you I work with my dad.
Now and then.
Back and forth.
How much did you make in 2025?
I can't give you a certain.
Did you make $10,000, do you think?
Yeah.
15?
Yeah.
20? I tell you what, you got to grow up. I'm extending your probation for a period of 3 months. He's scheduled to come off on November, December, January, February, March, April 1 of 26, right?
His prosecutor review is scheduled for.
Right. So we're going to extend you until May, June, July 1 of 26. I feel sorry for you. I'm not upset with you.
No.
Tell me, talk to me. What? I'll set you up at a payment plan.
Yeah, it's already, I'm a man, already, at that time when I came here and I took the plea, I should have. But it's like, I'm already into what I'm in now. So I just really wanted to, I'm that type of person, like when it was just a lot on me at that time. But I shouldn't even be on probation, to be honest with you. But it's like I already accept what the plea and everything. So it is what it is.
Do you have the police report? See, I know how I conduct my work here. Okay?
No, definitely.
And I know that I make sure when somebody pleads guilty, that they're guilty of the offense charged or that they plead to. I ask questions.
And you definitely asked, it was not on you, but just at that time, I was just.
Well, wait a second. Wait, you're telling me you weren't guilty. That's what you're saying in so many words. Judge, I wasn't guilty. I shouldn't have taken the plea. Is that, am I misreading or is that not what you're telling me?
No, that's exactly, I just said, but another thing I said also is I took the plea, so I have to take care of what I have to take care of.
I'm just going to read you part of the police report.
I remember.
The store manager told the officer that you were one of the individuals involved in a fraud complaint. And he said that, you began walking away. He told you to wait inside to keep both parties separated. You disobeyed and began walking away from him and the store manager. The officer said that he noticed you walking off in the distance toward the parking lot away from his view. He yelled at you, "You're not free to leave." You looked at him. He responded by saying, "Yes, you." You continued to walk away from him, not complying. And Officer Meadows then made the scene and advised Ramel, you were being detained for fraud. He ordered you to take a seat 5 times total to avoid you from leaving the scene. You continue, this is the officer.
Okay.
Ramel continuously disobeyed and would not listen to Officer Meadows' verbal commands. Ramel stated, you're not detaining me for nothing, bro.
That's not.
Well, I don't know. I could go back and listen to the tape and listen to what you told me at the time of the plea. But I guarantee you did not say anything close to remotely saying, I didn't commit this crime.
Yeah, because at that time, like I told you, there's a lot going on. Then I had.
So you're coming, are you telling me you lied to me at the time of the plea?
No, I didn't lie to you at all. I lied to you about what?
I'm asking you, when I asked you questions about your involvement to establish what we call a factual basis on the resistant obstructing officer, were you telling me the truth or were you lying?
I was telling you, I told you the complete truth.
Well, if you told me the complete truth, stop. There is no way that I would have taken a plea if you didn't, out of your mouth, come up with words to establish that you resisted and obstructed an officer. So let's get away from that. That's past. That's done. That's finished. You already did that. I already accepted your plea. I know how I conduct my work here. I would never have accepted a plea if you sat there and said, Judge, I didn't do anything wrong. Now, we're done talking about that. You want to divert attention here from why you didn't do what you're supposed to do. You're going to say you didn't, or you don't want to, but I'm not going to argue with you. I'm trying to figure out what I can do to make you think differently. Maybe you're not going to ever think differently. Maybe you're going to think it's okay to just not do what you're supposed to do and talk to police officers like this. That's your business. But sometimes you're going to have to pay the piper. Here's what I'm doing. I'm going to go ahead and extend your probation until July 1. You have to pay additional. I won't assess additional costs. You're to pay additional probation fees of $60. We're going to set you up on a payment plan. I need a new review hearing date sometime in July. I'm sorry, in the latter part of June, Heather. You are to pay $50 per week. I'm going to start this beginning February. You're going to have to get to work. I don't know what to tell you. Beginning February 20th. I won't make you do the court work program, but you didn't complete that. You didn't do your community service. Defendant to perform 30 hours of community service, no longer required, Jessica, to do court work. 30 hours of community service, which will cover all community service / court work program. So in other words, I'm not making him do the 8 hours. If he's already done some of the 8 hours of community service, we're going to give him credit for that. I'll give him credit for that. We're not going to make him do the court work program. And we're going to refund the $35 fee that I charged initially on the court work program. Refund $35 fee. So we'll take that off of this balance. So they'll let you know what your balance is. You're going to pay 50 per week beginning February 20th, and you have to complete 30 hours of community service. I'm going to give you to be done by April 1st. That's going to give you 6 weeks. It doesn't sound like you're working. So you're going to be able to do 30 hours of community service by then. Then your new review hearing date, do you have that yet, Heather?
Yes, that'll be June 24th.
At 8:30 in the morning, okay? And you still have, what's that?
I'm sorry, his new balance with the court work program out and the $60 added is $545.
Okay. So your new review hearing date will be June the 24th at 8:30. You're going to get your notice on that. You're going to get going. Don't be angry. Life's too short to be angry.
I'm not angry at all. And that's what I was saying earlier, like, I wasn't saying, like, at that time when I said I took the plea and I'm still on probation now, like, I wasn't saying, like.
You were saying you shouldn't have taken the plea, that you didn't do anything wrong.
Yeah, but I already took the plea, so I still have to take care of my business.
And I'm telling you that you did something wrong, or else you lied to me when I asked you questions about what you did. That's all. I don't ask somebody, how do you plead to resist and obstruct an officer? I don't have somebody say guilty and then me say, what did you do that makes you guilty of that? I did absolutely nothing wrong. I was not in the wrong. I'm not taking somebody's plea. That's the way it works.
What's that?
So that's it. I wish you well. If you have questions, go with her. Listen to me. If you need more time on your fines, no problem. Call the court on or before any due date. We'll go on Zoom. I'll give you an extension. I don't care how many times we have to do that. Okay? Good luck. David Elwood Myers, 25B 149-844.
Good afternoon, Judge, and as I gave Mr. Myers.
Mr. Myers, your name?
David Elwood Myers, Your Honor.
Did we try to take this plea before we did, didn't we?
Yes, sir. And then ultimately we did, Mr. Myers did request a jury trial. We set the final pretrial for today. We were able to reach a resolution.
Okay, so he's going to plead down to disorderly conduct, the assault to be dismissed, true?
Correct.
If you plead to disorderly person, I'm going to dismiss the assault charge. The possible penalties here are up to 500 fines, 90 days jail, costs of all those. You understand that? Did you sign, read, and understand the advice of rights? If you plead guilty, you'll be giving up all the rights, and we're not going to have a trial of any kind. You understand that? So, all right. To the charge, disorderly person, how do you plead? October 18 at 25 at 1:44 p.m. were you at 26291 Pennsylvania in Brownstown? What did you do that makes you guilty of disorderly conduct? Hang on. Say you what?
Gail, the one.
Who's Gail?
The alleged victim. My aunt.
Okay, you gave her the middle finger?
Yes, sir.
Did you also tell her you were going to bust her sons and her teeth out? Talk to me. Did you say that?
I gave her the finger, yeah. Judge, he gave her the finger. Ultimately, for the disorderly judge, there was an altercation between Mr. Meyer and the complaining witness, and ultimately the police was called, Judge, because this was outside in public.
Okay, so you two were.
Judge, just a little background here to make it a little easier to understand.
Yeah.
The 2/6 is it 26271? The 26291.
26291.
26291 address was owned by Mr. Meyer's uncle, who was married to the complaining witness.
And this was outside.
Right, and the house next door would also belong to the uncle who had passed away, left Mr. Myers everything in the house. He was in the process of cleaning that property out when this altercation happened. It was outside and it was in public.
All right, and you were yelling at her?
There were some back and forth.
I give her the fingers. I remember pretty much what happened.
Well, tell me. Tell me.
She stole.
I don't know that constitutes disorderly conduct so far. Go ahead and tell me what you did that meets the standard. Were you arguing?
Yes, sir, I was arguing.
And were you using any vulgar language? Well, I wasn't there. I don't know. You were there.
I've had time with this woman since my uncle died. She's been at my uncle's house.
I don't want to hear it.
All right, bro.
I want to know what you did, if anything, that makes you guilty of disorderly conduct on that day, not just popping the bird. Were you yelling at her?
Yes, sir.
Using vulgar language? Were other people in the area that could hear you?
Yes.
What kind of, you don't have to say it in here. What kind of vulgar language were you using? F-bombs?
Probably.
Well, that probably.
Well, yes, probably.
Most likely.
Most likely, Your Honor. Those are.
Were you drunk?
No.
Well, you don't remember, this was only 3 months ago.
Right.
Judge, Mr. Myers has some mental health issues.
Okay.
I believe that he.
Okay.
I was hospitalized 2 months.
Okay. So just talk to me a second. Do you think you used F-bombs on that day?
That's right.
And this was with the victim is who to you again?
Would be my uncle's sister.
So
That would be my aunt through marriage.
I see. Okay. Are you right now on probation or parole?
No,
Anybody force you to plead guilty?
no, sir.
Are you satisfied with this?
Yeah.
I'll accept your plea. I'll dismiss the A and B or assault charge. I'll refer you. Was there alcohol involved?
I'm sorry?
Alcohol or drugs involved?
No.
Pre-sentence report, sentence date. We can do this in 2 weeks. If Mr. Gaith will be here, Heather, that would be what, on the 25th?
Yes, Judge, we could do 9:30. Or we could do 8:30. It's gonna be.
Yeah,
fun.
let's do 8:30. If I give them 9:30, people want to show up at 10 o'clock, 11 o'clock. Be here at 8:30. Go down the hall, get your notice, go over to probation. You'll be interviewed, okay?
Go get your notice from the clerk's window
Thank you.
and then go to probation right across the hall.
I wish you well. Good luck.
Thank you, Judge.
John, can you call in Brownstown? I just want to know where all these people are. If they're
No.
I have one more, Judge, Ms. Russell.
okay,
I believe that's the last one that's waiting for me.
okay,
Okay, thanks. She heard, she's coming in.
good. We can write up no-shows on all these if they're not here. I mean,
All right, pass steps that in. Ready to go. Okay, Judge. Ready to go.
even the court officers are wise guys now, you know?
No.
What? How you guys doing?
I just know how you think.
Oh, say, okay.
How you doing today? Good. I just want to write these up. Do we have many left?
I'm only waiting for Mr. Hart on Cosby and then May's talking to Ms. Russell, and that's all I have.
Okay, so Mr. Hart and his client and the victim are going to be here, right? Good. I don't know why I set that so late. Why did I set that for 11:45?
I believe Mr. Hart had it out.
Okay, all right, good enough. Good, thanks. If anything else is back there and they haven't checked in, you can just write them up and we'll put them on record.
Is there anything else I have?
Perfect, thank you. Wow.
Your Honor, you don't have a problem. I get up and walk a little bit.
No, go ahead. It's good for you.
Just had knee surgery.
Oh, that's too bad. A knee replacement?
Yes,
I'm sorry.
it's going well.
Good. You look like you're in good shape for a guy who's 50 years old.
Thank you, Your Honor.
And 78.
No, you look good, both of you. Okay, stay there. You're good.
But he didn't show up on the one, but on 2000s.
Yeah, that's weird, Judge.
So he's charged with deadly conduct, discharging a firearm, a third-degree felony in 2000. That bond was $25,000. Has been revoked. It is now $50,000 plus GPS. 23 CR 2001, Cameron Smith, who was failed to appear. Hold it down. Thank you. Was indicted on the second-degree felony of aggravated assault with a deadly weapon. That is also a $25,000 bond. He has failed to appear. It is revoked. It is doubled to $50,000 as well as the preceding indictment. So now has a total of $100,000 in bonds plus a GPS device must be on him at all times. No, he didn't pay for his GPS device. And it's been revoked from the bondsman. The bond was bigger than that. What was the one?
I know there was an issue with GPS. There's why I haven't here.
With what? The what?
GPS.
How do you spell that?
J-E-E. I'm not sure.
Exactly like it sounds. Yeah, that makes sense.
Give me a hard time, Judge.
Decorum White.
Mr. White, right here, Your Honor. We would like to set this for trial. We have filled out our plea rejection.
Let me just go, just to make sure.
Sure.
That the record shows, since we're looking at 20 years in prison.
Yes.
25 CR 1158 is called the State of Texas versus Jacorin White. That is you, correct? And you were here with Mr. West, you were attorney and the state's attorney. You were indicted back in August of last year for the second-degree felony assault on a peace officer. If convicted, that carries with it no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can be assessed as well. Let me see if I can read this. Just a second. It is tiny, super tiny. It's like I'm doing an eye test at the eye doctor here before. It says, the defendant stepped out of his vehicle. This all was at 1:30 in the morning when everything was supposed to be closed. And stepped out of the vehicle. They proceeded to arrest him, and then the defendant struck the officer in his face. And while he was attempting to investigate the case of why these people were there at 1:30 in the morning and not leaving a public area where the owner of the business, the property manager, arrived and advised the defendant and some other person he was with to leave, and they refused to do it at 1:30. So that's what that's all about. And okay, let's put that to file. There is no deal on that. Okay. On that. Oh, that's what it said.
Lay down some framework. I have.
Well, this is actually Nelson.
Yes, sir. I have a motion filed. That's going to compensate. We have a plea in place.
Yeah.
But that's whenever I talk to it gets dicey. And I just want to make sure that she knows that time. We get over that. Good to take it. That's about it.
We're talking, we had an evaluation done.
We have
long ago, but if the question becomes, what's going on? You know, what we are careful about is opening the door. I mean, theoretically, we could be doing this every day. You know, every day, just to see if they competent and see what goes on. And that's before we know it, we're out of money.
Aware of I don't want to agree to something where she's not fully understanding what's going on, and it seems there's ebbs and flows to image of the gas. So we have an agreement. We're ready to execute it on automotive coming from.
No, I didn't. Where were you going today? Nowhere. I was sort of on my desk.
I'd like to have consider getting her competency update again. Should you find out?
We got to articulate in the record why, because we're about to, this thing costs $1,000.
Understood.
So it's, I mean, and there, we can do this every day. And here's
John West.
we do something, but unless we take, unless we do immediately upon an evaluation that's successful, we're going to be like that doing the same. So,
and
because I guess what you're doing is you were calling this decision based on our discussions we have out here for they're going to how they speak in their books. They're in control of that.
It's not your case. So,
and should we rely on the evaluation that's already been completed? Mr. Boyd and I discussed some continued image in all those terms of the probation carrying on. So I think we're good. It's just I feel it is my duty to alert of any type of concerns. And I've had an invitation with her today. She seems pretty lucid today. So I'm prepared to take a tablet back there and
let's try it.
Listen.
And we got to trust the expert, but
anyway, I'm like,
you don't know where y'all are on.
Oh, we're just waiting for him to get here. He's about to start to file about it. Judge is about to close the back to the file, so he's waiting. And so it'll be good to break.
Y'all are on trial, Doc?
They are. No, we're all down.
Braden Hensley. What are we doing?
Yeah, on this one, I just need one more announcement. You said between my hearings, the trial schedule and his work and school schedule, it's been a little, he's had some difficulty getting in.
So we're going on 2 years.
That's all I'm waiting for today from this
Okay,
case.
right along and
Yes.
enough. Fisher got Vegas. My dad used to tell me.
Yes, and
I didn't understand. When we didn't even have a pond in the backyard. Where I'm supposed to go there.
we do have all the discovery, Judge. Like I said, Mr. Tepe, he's working full time and
What's the offer on this one? I'm just curious. Is it a deferred or unappealable probation?
No, sir. It's
time off.
What does he have prior conviction? 85.
Yes. Me. No, let's see. Oh, let me double check. I don't want to lie to you. Oh. Yeah, I just got out of TDC battle. That's March of last year.
So you were in prison?
Yes, sir.
Okay, well, there's the, for what?
Probation, got my probation revoked.
For what? What were you on probation for? Is in this court?
No, sir, it was in Hardin County.
No, I wouldn't know anything about them, but for what?
I had, possession of controlled substance and burglary of a habitation. Yeah. That had happened a while back and I got put on probation for 5 years. Yeah, I failed a drug test and I got my probation revoked.
On both cases?
Yes, sir.
And what were you sentenced to?
3 years. I did half of that. A year. So his possession was third degree, Judge, and in his then the drug test falsification issue was a misdemeanor. So I believe it was just 12, and then the burglary of a second degree. So he had a second and third.
Okay, so this one is a third. Is, you know, on these kinds of things, the thing you're worried about is where the feds want to pick it up or not. As the state doesn't know that the feds are interested in this, as far as you know.
not that I know of.
This, that's always catastrophic.
Yes, my understanding, Judge, this didn't arise from a Nick report. It arose from a work phone that Mr. Hensley had previously been in possession of, that someone else saw some material on there and they're attributing it to the defendant.
But I know what's on my phone. Okay, so what are we going to put as a trial?
I mean, Judge, if the court wants to go ahead and set it on the trial docket,
because it's 2 years old.
Yes, we can. You know, if there's going to be a different resolution,
Just separate on the trial docket.
All right,
let's get ready. Okay,
thank you.
And do you understand you're not eligible for probation in this? In front of a jury. Whatever the offer is, that's their business. Are y'all going to file notice of enhancement of sentence or something like that?
This is Mr. Ham's case, Judge, but I just noted the priors and I'll let him know. So yes,
Were they final before the commission of this offense, as far as you can tell?
Not that I can tell, Judge.
You don't want no. It may or may not be enhanced.
Yes.
Yeah. When were you convicted? No, when were you convicted of those other cases?
The first one was in 2019 and the second one was 2022.
Okay. Well, that's not good. Because when it's alleged you committed this offense in 24, which would have been, if you're right, after those were filed. So those could very well be all of that. If it's just one, it becomes a third degree, becomes a second degree. Up to 20 years of this without any probation. Yes, sir. Unless it comes from the court and it. All right. We'll just put Mr. Wesley on the trial docket. Thank you.
Thank you, Your Honor.
Okay, I've got Mr. Jeffries working on something, I guess.
Yes, sir.
And then I have Joey Childress. Joey Childress, and this is Lori Perozzo, but is she still? Are they finished? They're finishing today. But Joey Childress, what is Joey Childress? Who has to be here? 25 CR 314. No answer in the courtroom. I asked if they had to call into the hall for Joey Childress, please. What's his by any chance?
15,000.
No response to the name called into the hallway. No response to that name called here in the courtroom. Defendant has failed to appear for his required attendance. Today, a warrant shall be issued for his arrest. And you said his bond was originally
15,000.
15,000. It is now doubled to $30,000. Plus, the defendant must have a GPS device so we know where he is when he's not in court when he's supposed to be. And then we are waiting Mr. Jeffries and Nilsson, Ashley Nilsson. And we will be going back into trial. Then here's Curtis's phones.
We'll leave him to the side and take some shoes.
He's already 25 minutes late. We're in short recess, getting ready for trial.
Next one.
I believe so.
That's Miss Tepe.
Oh, she's in the next one?
Yes, but she was here at 9.
No, I don't have a problem with her. It's him. Am I ready?
You're all set.
Okay. I don't know what's gonna happen. We'll see. Court calls the case, People versus Stephen Comer.
Mr. Stephen Comer. Please state your name for the record, sir.
Stephen Comer. Thank you.
Thank you, Judge. We were here for a review hearing. My records indicate that Mr. Comer still has approximately a $420 balance.
Yes.
The last payment that we saw on our computer, I think, was from October. Mr. Comer indicated to my intern, I believe, that he has gonna need some additional time to try to pay this off. I think he's hoping with tax returns, he'll be able to take care of it.
So how much more time do you need, young man?
Just 2 months.
Just 2 months?
Yes, sir.
No, it's okay. Give me my May day. What? I said May. May 8th, thank you. I'll turn this to May 8th, 2026, 9 a.m. Pending to paid balance by the.
Thank you, Judge.
All right, thank you, sir.
All right, thank you.
Calls the cases of the people versus Taquisha Edwards. Uh-oh.
Ron Brown appearing on behalf of Ms. Edwards. Please state your name.
Taquisha Edwards.
All right.
Your Honor, she made two payments of $225 on each file. I provided receipts to the court.
Yeah.
Please excuse me. I know it's supposed to be 200 a month.
What'd you say?
I said, please excuse me. I know it's supposed to be 200 a month. My health insurance flipped. I'm a critical diabetic. I have stage 3 kidney disease.
Okay.
And I have to pay for my medication now. And it's not cheap at all. But Mr. Stacy, the guy that was here earlier, explained to me that I can go through somebody else. It just started last week. So I'm going to find a way to get that situation. Yeah. I actually just took, also, I've been garnished. I've been being garnished for about 2 years now. I only bring in $800 a month. I'm living from paycheck to paycheck at the moment. Just 2 checks alone is my rent.
Sometimes she has to choose between paying court and medicine.
Yeah.
Medicine.
Not even just court, even over my head. When I can't pay for my medication, I actually get it from my grandmother because she's a diabetic as well. So I try to make do what I can do at the most.
If she was here at 8:30.
So I'm supposed to believe all that?
It's up to you, Judge.
Yes.
Bless her heart. It's up to me. You guys have learned that.
I'm trying my best.
Who's with you?
My spouse, my boyfriend. In case anything went wrong, I didn't see how you can get down. Trust me. I know. No offense.
Whoa,
no offense. I gotta be safe this hard.
So in case things started going sideways, what was he gonna do?
What he can do.
What was he gonna do? So
at least try to pay my bills until I get out.
Oh.
She had a plan B.
So he got.
I do have a plan B. My grandmother was my plan B.
So he's got money. So if I put her in danger, we can get his money.
Oh, no. So I'm gonna talk.
No, he will protect you. I'm gonna tell you how I know that. You know how I know that? The moment when I said, well, who is that? And then somebody said something, and I said, I like her. I don't like him. He had his arm up like this. He immediately like, okay, I can't let the baby get in trouble. I'm just going. He took that arm up, started moving to the side. Like he didn't know you. I appreciated that.
Like that sometimes.
All right, young lady. Sounds like you're just trying to make
I'm trying to make a living.
Right? $825 and $7.
And I paid $450 on Monday.
Applied $225.
It was $225.
Yeah, I saw that receipt, but that should be mine. Is that what you got? Did they take that off already?
So 15 to bring two together and let me see what.
It's like 1,080 something.
Hang on.
Okay, so in the case ending 1072, the current balance is 600 even.
Got it.
Let me look it up.
480 something.
483, yes, in the other case.
For what?
483.
Got it.
So it's 1083 between the two matters.
Okay.
And how long is it going to take you to try to get that done?
Your Honor, can she do 75 a month?
That's fine. But I'll try to, if I can, I will try to double it to make sure that I'm trying to pay it off because I have till May, as you gave me.
Bless your heart. You got all that going on. And
Your Honor, it's been
I
50.
know, I gotta appreciate you because you're trying to, with everything else that you got going on, trying to do whatever you're gonna do, you're still trying to make sure that you keep to your word.
My grandma always told me, you do the crime, you do the time, right?
Tell me that sometimes, although people do things, maybe the greatest gift that you can give yourself and you can give others, even though you've done something wrong, is forgiveness.
Always.
So here's what I'm gonna do today. In each of your cases, I'm gonna waive everything except the state minimums, which I can't waive, which is $125.
I could pay that today, sir.
We're all done.
Thank you.
You're welcome. All
I'm
right,
sorry about the car.
just do me a favor and you take care of yourself. You hear me? That's all I wanted.
Thank you.
All right, you're welcome. And young man, you got a good one. Take care of her. You hear me? I know you do. All right. You take care. Court calls the case, People versus Zachary Harrington.
Judge, portion the Assistant Public Defender on behalf of Mr. Zachary Harrington. Hopefully he's on Zoom.
Harrington? No. No.
All right, well, we did reach out to Mr. Harrington. Your Honor, but he owes approximately $1,424. I do not know why he is not present. For the record, I will request adjournment, but I do not know where Mr. Harrington is.
Bench warrant will issue for defendant's failure to appear, bond $15,000. Give a 10% privilege, that warrant will issue immediately.
Thank you, Judge.
Thank you. Court calls the case, People versus Valencia Montgomery.
Attorney Feaster, Assistant Public Defender, standing in for Mr. Brown on behalf of Valencia Montgomery. If that is you, Ms. Montgomery, please state your, please unmute and state your name for the record.
Valencia Montgomery.
Looks like this is also a show called Judge.
Yeah, she owes 5.
Or daddy. Background, thank you.
She owes 594.
Ms. Montgomery, when can you pay that, or can you pay on that?
So Judge Simpson, Your Honor, I
Yes,
am
ma'am.
back because my housing situation still hasn't changed. I'm literally not even making 40 hours at work anymore. I am a dialysis technician, so this is what I do every day. But they have drastically cut our hours. And my son, who just graduated college, I'm very proud of him. They are now starting to hit me for his student loan. And so I was wondering if you could be so kind and pass some of that forgiveness on down to me, because I'm trying.
I only have so much forgiveness a day. I ran out on that last one.
Goodness gracious. But I'm trying.
No, I gotta quit being
I really
forgiving.
No, you don't.
Then everybody wants it. And then it loses its value.
It's still valuable to me.
Not with me.
What?
Not
It's
with
still
me.
valuable to me, Judge.
Not with me. I can come clean up the courtyard, or I come read to the prisoners. I won't be a lost cause for giving me. I promise you.
I don't know what to say, Judge.
Don't know what to say about what?
I think she offered to come clean up the courthouse.
I don't.
I did.
Hey,
I did with a
those days
smile.
for us are over. You don't have to do all that. You don't. Lord have mercy. I ain't did that. I don't have any of this.
I'm literally
restitution. That's
paying
bad.
like 100. I'm paying 1,100 a week. I'm okay. And I got receipts to prove that.
So I can't.
Can't waive that.
So I can't waive it because you still owe restitution. How much of restitution? 314 of what you have is restitution.
Okay.
So what Judge is saying is you, at a very minimum, have to pay 314. He can't give you that much grace and waive that for you. So if you pay that, maybe he'll be willing.
How long will it take you to get that restitution paid? That's got to be paid in cash.
The 314,
Yes, ma'am.
I can do that next month.
Next
Everything is
month?
sent. Yes.
All right, so.
And you'll never have to see me again. And the only time I'll see you was on YouTube.
I don't mind seeing people. But
no, I'd rather watch
sometimes they get on my nerves, but I'm all right.
I'd rather watch you.
I'm gonna indicate defendant is to pay all her restitution by March 31st, 2026. I'll adjourn this hearing to April 8th, 2026, 9 a.m. or as your invite indicates, and then I'll see what we can do.
So make sure you take it at 314, please, Ms. Montgomery.
I will. And then I'll be free.
We'll see you on April 8th.
No, Ms. Montgomery, you were born free. Just think about that for a moment. All right. We'll just leave that. All right. We'll see you in April.
Thank you.
Thank you, Judge.
Thank you. Court calls the case before us, Lori Ann Pearson.
Ready to Judge Torshall Feaster, the public defender standing Brown for Miss Pearson.
She's in Zoom. It's a show cause.
Yes, Judge.
Miss Pearson? Lori Ann Pearson? Really? Lori Ann Pearson. All right, put in the chat. She didn't respond. I'll adjourn this out to March 11th.
Thank you, Judge.
2026, 9 a.m. or is invited Kate. We'll do.
And the arraignments in each of these cases, and can we proceed in a summary fashion?
Yes, Your Honor.
And it's my understanding that Ms. Nielsen will be entering a plea of guilty to this third degree felony of obstruction or retaliation in 24 CR 1985. And as part of the agreement, the other case in 24 CR 1986, a third degree felony of obstruction or retaliation, that case will be dismissed. Is that our understanding? Correct?
Yes, sir.
Is that what you understanding as well, Ms. Nielsen?
Yes.
Okay. First of all, earlier, there was a question that arose on the defendants as to the defendant's competency. And the court ordered Dr. Ed Grippon, licensed psychiatrist here in Jefferson County, to evaluate the defendant. He did evaluate the defendant, and there is a product of his evaluation that is reflected in this 4-page report dated November 3rd, 2025. And have the parties had an opportunity to review it?
Yes, Your Honor.
And I've marked this as court's exhibit number 1 for today in this plea hearing. Any objection to its admission, defense, or state? It will be made a part of the record. And in summary, it states that Ms. Nelson is competent to proceed to a resolution of her legal issues at this time. She is a lady who understands her current legal charge and has adequate understandings of the legal proceedings. And additionally, she does possess the ability to communicate with her attorney with a reasonable degree of rational understanding for the preparation of this case. And all of that is made part of this as court's exhibit number 1, and it will be kept sealed, except for purposes of any review as necessary legally, but not publicly. All right. All right, Ms. Nelson, in summary, this indictment in 1985 states that on or about August 10th, 2024, in Jefferson County, Texas, you committed the 3rd-degree felony of obstruction or retaliation. It states you did intentionally or knowingly threaten to harm another, the victim, by threatening assault or murder to prevent or delay the service of the complainant as a person who had reported the occurrence of a crime. Do you understand what all this states? You have to speak out.
Yes, sir.
Yes, ma'am. Thank you very much. This is a 3rd-degree felony, which means if convicted, you face no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Do you understand the punishment range in this matter?
Yes, sir.
There's only one silence that now works, and it finds its way around the room. The defendant's got to sign this judicial admission at the bottom, waiving rights of appeal in a minute. An agreement has been reached where you would be pleading guilty, placed on deferred or unadjudicated probation, which means you would not be found guilty so long as you followed the terms and conditions of probation, which can be up to 5 years in length. You do well, it gets shortened to 1/3. So a third of 5 years is what? 1 2/3. I'm doing the math for you.
Well, and this one, Your Honor, is the 3rd degree. I believe it was just recommended as the 5 years, but because she has done 489 days in jail as already on part of this. So I guess that's what Mr. Jeffers was asking the court for the 5 years.
Well, I'm going to do that.
Okay.
But
Yes, sir.
I mean, the probation can be shortened.
Yes,
I think just deferred probation is what.
Yes, sir.
Deferred or unadjudicated probation. Yeah, we can do it. It can be up to 10 years in length, but I'm going to go with what the plan is here and 5, and then it gets shortened for good behavior. You get rewarded. Then as part of the agreement, the other case that's pending, 24 CR 1986, which is another obstruction of retaliation, 3rd-degree felony, that will be dismissed and torn up and thrown in the trash, as it were. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement in these cases, you have no right of appeal of your cases. Do you understand?
Yes.
How do you plead to this charge in 1985, 3rd-degree felony, obstruction or retaliation, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes.
I'm going to show you what's marked as State's Exhibit 1. Now I'm going to give this to you so you can sign at the bottom. Do you see State's Exhibit 1 and you're signing that at the bottom? That waives all rights of appeal if I follow this agreement. I tend to, but do you see your other signature up at the top on the top part?
Yes.
Did you understand the contents and discuss it with your attorney? Is everything true and correct here?
Yes.
State's Exhibit 1 is tendered into evidence and without objection, Mr. Jeffries, it is admitted. This states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. As we stated, you were competent to do so. And Dr. Edgar Fine, licensed psychiatrist here in Jefferson County, has evaluated you and deemed you to be fit and competent to stand trial and take care of your legal proceedings. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You are guilty of this offense and any lesser included offenses. And you are totally satisfied with the representation provided by your lawyer. You have also read this instrument and understand the indictment fully. All of this, it states, is true, so help you God. States Exhibit 1 is made a part of the record for all purposes. Any objection? No. If nothing further, I will find as follows that Ms. Nilsson, you are indeed mentally competent to enter your guilty plea. It is freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. And even though there's sufficient evidence from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this case, I'm not going to do so, as long as you follow those terms and conditions of probation in this deferred adjudicated probation order I am signing. You will be placed on unadjudicated probation for 5 years. You do well, it will be shortened. So there will be special terms and conditions of probation, and you, among other things, will be placed on a mental health caseload. And that helps you if you have any issues understanding the probation and what decisions you might make. You follow what the suggestions are and directives of the probation office. They will guide you. Their goal is to successfully bring you through this probation to complete it successfully. So at the end, if it's just a year and 2/3, I will dismiss this case as well as I'm dismissing the other one right now. So this is a win-win for you. So, but it's your part. You got to run through the tape. We can't do it for you. You've got to complete the requirements. Are you going to do it well?
Yes, sir.
I know you will. All right, and I have faith in you. Anything else?
Judge, there will be also, there was a misdemeanor trespass that was all part of the same thing that will be dismissed as well in misdemeanor.
All right. You understand? There's some other case that's going to be dismissed, and I'm going to dismiss this cause number 1986. And that is that.
Thank you, John.
Thanks. Yeah. See you. Thank you.
You haven't dealt with it before? I don't think I've ever seen it.
Okay, here it is. Thank you.
The same guys. Always saying,
And here's one, Nelson, and two Nelson. And we're back again to Roberto Santana Mears. And they're doing a plea now, aren't they?
no, Judge, we have our translator.
Oh, we're ready to go.
I was telling you, and
Yeah, I'm sorry. I got thrown off, and I remember everything now. Sorry.
the chair.
It's all coming back to me now. All right. Are the parties ready to proceed? State and defense. Okay. Who is going to be your next witness?
If I could, I'd like to put two quick matters on the record, and then I'll cover that for.
Two quick matters. So quickly, what are the matters?
All right, so the state has corrected the issue with State's Exhibit 1. We're leaving that in the record that contains the, for the court's benefit, states, and we're submitting States 1A, which is the correctly redacted deal where it's muted up until a certain point in regards to the court.
Redacted what? No.
Well, it's removed the audio portion up until about the
what item? Well, the item which is described as a
It's the body cam footage that the court entered a ruling on State's Exhibit 1. We've now made those adjustments and have it corrected to where only States 1A would go back to the jury that has it properly muted where they cannot get to the audio portion.
Any objections?
Judge, I have no objection to there being a substitution of states 1 with 1A, but I would prefer to have states 1 completely removed from evidence.
Judge, it needs to I agree it shouldn't go back to the jury, but it cannot be removed. It needs to become the court's exhibit.
Okay. Again, for the record, what has been extracted from 1 into 1A? Or
There is audio that was taken away from states exhibit 1 because of a hearsay objection that I had lodged to certain audio elements on that. I believe 1A is a substitution of the same exact length and time of video that states exhibit 1 is. However, it just doesn't have that audio component to it.
That's correct.
so it is, the original is always left in the record if necessary for a review on posterity. Some issue comes up about whether 1A was correctly introduced or was correctly allowed. And generally, there's never an issue about it. But if 1A is an edited version, when again, the parties agree that this is to be admitted without objection, there shouldn't be a problem, but we always provide an original if necessary, something comes up, because if we don't, the original can be discarded. And if there's an issue, then there's nothing we can do and it leaves it open. And that's problematic. So 1 goes in, it's sealed, and is not going to be presented to the jury and is only to be used posterity for any review of the record that may be necessary. States Exhibit 1A will be admitted.
Thank you, Judge.
And we'll do that in front of the jury, right? When they come back in.
I was doing that for the purpose of the record. I will do it again in front of the jury.
We'll just introduce,
but I don't think
we'll just introduce 1A. We won't talk about States Exhibit 1. It will give them something to think about that is unnecessary for their deliberations to think about.
Let me hold that at my desk so I'll remember to do that.
All right, let's bring the jury.
Second matter.
There's a second matter.
I said 2. The state has added a witness, and I just wanted to inform the court. I have 2 witnesses this morning. The remaining was Eduardo Mendez, and then the state is calling Naya Knighton. I've given the defense notice about that this morning.
Anything you say? Defense.
Yes, Judge, I would have an objection to that witness being called because she was not on my provided witness list prior to the start of trial. This is a shock and surprise to me in regards to calling that witness, but not only that, she is not one of the doctors that checked Mr. Mendez out at the emergency room. She has no personal knowledge of the injuries. She has no knowledge of anything having to do with the scene or the incident at hand. It's my understanding that she would purely be coming in to testify about serious bodily injuries and what she thinks the injuries look like. And she's not a medical doctor. She's not the one who examined him. So I would have an objection to that testimony, being as she has no personal knowledge of any of those things.
And response.
She is a forensic nurse examiner, which I think the court is familiar with. She's testified in here multiple times. The state is calling her as an expert witness because of the questions and cross-examination by defense counsel about the issues of serious bodily injury. She will only be testifying about matters that are contained within the record and her interpretation. And so we feel like it's just and proper.
And the court finds that the representations from the state make it a relevant matter, and it becomes relevant and is now impromptu because of the state's representations that I am not going to question unless otherwise shown necessary, but that it isn't a matter that has arisen due to the defense cross-examination or other evidence that has been presented during this trial. And thus, the court finds it is relevant and admissible, and trials evolve, matters evolve. What is planned, there's always, I was told, 3 types of cases: the one you plan to try, the one you try, and then the one you wish you would have tried. And then the idea is to kind of, if you can put all of those as close together as possible, they never overlap perfectly. And so we will, I will allow under those limited reasons that matter to be presented. Okay. Anything else?
No, Your Honor.
And defense. All right, let's bring the jury in. Thank you. And I guess the interpreter will swear you in.
Just the camera like you want it.
Yeah, just please raise your right hand and tell us your full name for the record, ma'am.
Erica Burge.
And do you solemnly swear or affirm that you will truly and accurately translate these proceedings from English to Spanish, Spanish to English, so that the defendant who primarily speaks Spanish will be able to understand the proceedings in his native tongue that he's familiar with, and that also the people who don't speak Spanish will be able to understand the English that you will translate into from Spanish in any statements that he may give and make if he.
Good morning. Sir, your name, please?
Bradley Steve Godley.
Caitlin Boyd, Aaron, Frozen Township.
All right, so. Sure. Thank you.
Well, I'm not worried about you.
Okay. No, I know. I'm gonna do a PSI. Oh, that's fine. You just listen. Use it doesn't go hey. Something. I'm not gonna be fair off the guy. But I trust you. But it's not. It's not. I'm doing the cameras. Wait, but what can I do, Judy? That's what you really asked me to do. I help. So, I mean, she's not gonna do it. All right, well, don't do it. It's business. Stadium. I need you to have this, devotion one. Do you have a clean copy of this, Caitlin? Do you have a clean copy of this police report? This one's underlined and.
Ready to move on.
Okay. She's getting a clean copy, so just give me 1 second if you would, please. All right. Let's go on the record. Okay, people against, while she's doing that, Bradley Stephen Cosby, 25B149283. All right, Mr. Hart, your appearance, please.
Good afternoon, Mark Hart, here on behalf of Mr. Cosby.
Mr. Cosby, your name?
Bradley Stephen Cosby.
All right, so I have a stipulated plea agreement form that says defendant is going to plead no contest, and I assume that's due to the possibility of civil litigation under 771.1 to disorderly person with the assault and battery to be dismissed. True?
Correct.
And you stipulate I can use the police report to establish a factual basis.
Yeah.
Sir, if you plead no contest to that charge, these are the possible penalties: up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
Yes.
All right, I'm just going to ask you to, John, give him the garbage, will you? Did you sign, read, and understand this advice of rights form? Go.
Yeah, I'm sorry. Okay.
This one here, did you sign this today?
Yes.
If you plead no contest, you'll be giving up all those rights, and there will not be a trial. Do you understand that?
Yes.
You know, I asked her for a clean copy. That's what caused her to go back there. I'll just use this one that's on, unless she comes in now. That's all right. Do you have a clean copy? All right, so we're going to have that marked Peoples 1. I've already started taking the plea. Sir, to the charge of disorderly conduct, how do you wish to plead?
No contest.
And you understand, I just want to cover this with you again. A no contest plea has the same effect as a guilty plea.
Yes.
You understand that?
Yes.
All right. Ms. Foley Carter, I didn't ask your appearance since we started this. Your name?
Fully part of Providence Township.
And you consulted with the victim who's in the courtroom.
I think you're.
All right. All right. Have you had that? Have you marked that? I'm going to need to review the report now. We'll have that marked Peoples 1. All right. Are you on probation or parole right now?
No.
Anybody force you to plead no contest?
No.
You ever been in trouble before?
No.
I'm going to accept your plea. I find there's a factual basis for the plea based on my review of the report. I'm going to accept the plea of no contest to disorderly. I'll take it under 771.1. I'll dismiss the A and B. I might sentence him right now.
Understood, Your Honor. I do understand that Mr. Colbert made a statement at sentencing. So
Come on up here, Mr. Cole. Mr. Hart, I think your name?
Justin Boyer.
You didn't go to the hospital or anything, correct? Was he under the influence of alcohol or drugs?
No, better than the of a person.
What's that?
He's not the kind of person. No, he's a good kid. He's not, you don't drink or anything like that.
Why don't you let them come up to the podium? You stand over there. Come on up here. I think I'm just going to sentence him now. If somebody thinks I shouldn't, they can tell me it's a first offense. Any objection to that?
No.
All right. Do you have any objection to that?
No.
And then, I'll save everybody from time having to come back here.
Yeah, it's supposed to be, we see him, he does that baby. He just kind of fell underneath the trap of his mother, false statements and.
All right, let's just wait. I'm going to let them talk first. Go ahead, Mr. Hart. What would you like to tell me? If you need time to gather your thoughts, no problem.
No, we're good.
Go ahead.
My client is gainfully employed. He's married. He's got a relatively new baby who just went through some horrific surgery.
Can I have a probation number?
This is kind of a family squabble situation that got out of control. He has no prior record. He's hoping he can do counseling with his pastor. He's a pastor himself. There's somebody higher up on the hierarchy where they preach. And he's hoping he can do his counseling with that person if the court orders counseling of any sort. That basically, he's not a troublemaker, even based on the statements that the complainant has made. And with that in mind, we would ask for the shortest period of probation the court deems appropriate. And I shouldn't do this, but I'm pretty sure there's not gonna be.
Did you hear me that I need a probation order? I'm sorry. Here I am. I'm sorry. Give me 1 second. All right. What would you like to say, if anything, sir?
You're all right, I have nothing to say. I would be saying what I want to say.
What would you like to say, Ms. Foley Carter? Anything?
Just leave some proceedings and determination to the court. I would just ask for no contact order.
And we would have no objection.
Mr. Cosby, what would you like to tell me? I mean, Mr. Cole, I'm sorry.
No, nothing. I just best court meetings. Yeah, I mean, he is like a son to me. I never even met you, but
you know what?
He's my nephew. He's like a son to me, though. I've raised Bradley, so I just court meetings. Yeah, we just kind of fell into a bad decision. For his mom, giving him false information, and unfortunately, it just misunderstanding. And
I'm sorry. What is the relationship between you two again? Can you remind me?
Listen to my family, though.
Okay.
This is Lisa Cosby's son.
Are things going to calm down over there?
Again, there's not. I can't tell you that. I don't know. My sister has a mental issue. She needs to seek help for it. I don't know what her goal is or her any fault would be in. But I haven't talked to her. I stay away from her, and we just find ourselves back in a situation, and she just can't help herself.
And Judge, for whatever it's this all arose as a result of my client getting a phone call saying that somebody at the house where this case took place had either beaten or was beating my client's others. He rushed over there.
Was this the video I saw in conjunction with some other case?
It was
That's why I videotape, because she makes those false statements. And
I know, but this has to stop over there.
that's my biggest goal. I want her to just stop. Hey, look.
6 months probation, 771. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. No contact with the victim. No contact with the victim at all. You cannot write, phone, see, text, email, or phone Justin Cole. You cannot have anybody else do any of those things for you or on your behalf. You're not to possess firearms or dangerous weapons. I do want you to attend the anger management weekend program, and I'm going to have you do 2 days of community service, and I'm going to give you until April the 10th to complete that. Okay. Fines are $150. Costs $125. $75 victims' rights fee. $50 justice assessment. So your fines and costs here amount to $400. Probation fees are $120. Your total's $520. You pay that. You stay out of trouble. Do your anger management program. 2 days community service. Don't possess firearms or dangerous weapons. Stay away from him. And I'll be glad to dismiss the case. You may be eligible for early discharge too. If you complete everything in 3 months, and your lawyer could get a hold of the prosecutor, because they're still going to have to move the dismiss under 771. If she doesn't have a problem with that, neither will I. In the meantime, I'm going to give you a review hearing date. You can give me one like in July if you can, Heather.
That'll be July 15th.
So July 15th at 8:30. Mr. Hurd, if he's compliant, you don't have to show up, okay? Yeah. Do you have all the money, or does he need time to pay?
No, I can pay.
All right, and you'll meet with probation, they'll instruct you, and you're all set. I wish you both well. Good luck. Nice to see you, Mr. Hart. Thank you, Ms. Foley Carter. Good luck.
Character evidence is allowed.
Not at all.
Do you know when and how to make proper objections?
No, sir.
Do you know when and how .25 CCCR 2538 and clause number 25 CCCR 2539. Both cases are styled the state of Texas versus Alvin Bryant. And Mr. Bryant appeared before the court earlier. Mr. Bryant signed an judge's explanation of rights to defendants without attorney. In that document, he stated that one of the waivers right to attorney represent himself. He also signed a waiver of counsel for purposes of entering a guilty plea or proceeding to trial. And Mr. Bryan has talked to the prosecutor in this case. The prosecutor relayed an offer to him, and that offer was rejected. Is that correct?
That's correct, Your Honor.
Is that correct?
Yes, sir.
And you want a trial?
Yes, sir.
Okay. Now, Mr. Bryan, I need to go over what is called a Ferretta warning. And the Ferretta warning is from Ferretta versus California, 422 United States 806. And I need to ask you some questions. Have you ever studied law?
No, sir.
Okay. Have you ever represented yourself in a criminal action?
No.
Do you understand the charges against you?
Yes.
Okay. And are you familiar with the exact legal elements for each charge?
Not all the way, but I will be.
Okay. Do you realize that if you're found guilty of more than one of these crimes, this may result in an order that the sentence be served consecutively, that is, one after another? Do you understand that?
Yes, Your Honor.
Do you realize that if you represent yourself, you are on your own? As a judge, I cannot tell you how you should try your case or even advise you as to how to try your case. I cannot help you in any way. Do you understand that?
Yes, Your Honor.
Are you familiar with the Texas rules of evidence and Texas case law?
Yes, Your Honor.
You are? Do you realize that the Texas rules of evidence and Texas case law govern what evidence is submitted, and in representing yourself, you must abide by those rules?
Yes, Your Honor.
Okay. Just have one question now.
if you have never studied law, how are you familiar with the Texas rules of evidence and Texas case law?
Just some of the cases that I've dealt with, discovery and all the evidence, just, I guess I watch my attorney do it enough.
Texas case law is, there's volumes of cases that has been, gone up to Court of Appeals and they've made opinions on. That's what I'm talking about.
Oh, yeah, I don't have anything, I don't know anything about that.
Okay. Now, you're not familiar with the Texas rules of evidence and Texas case law. So, for example, do you know how to conduct a voir dire examination?
Cross-referencing?
Voir dire is picking a jury.
No, I have no idea how to do
Okay.
that.
Do you know what are the grounds for excusing a juror for cause?
No, sir.
Do you know what is hearsay?
Yes.
Okay. Do you know what are some of the exceptions to hearsay?
I would have to study up on it and look into it.
Okay. Do you know what is proper impeachment of a witness?
No, sir.
Do you know when character evidence is allowed?
Not at all.
Do you know when and how to make proper objections?
No, sir.
Do you know when and how to move for a directed verdict?
No, sir.
Do you know how to offer evidence to protect the record for appeal?
No, sir.
Do you know the proper grounds for a mistrial?
Not all the way.
Okay. Are you aware that failure to timely move for a mistrial may waive crucial mistakes made by the state or this court? Do you know how to request and object to a jury instruction?
No, sir.
Are you familiar with the Texas rules of criminal procedure?
No, sir.
Do you realize that those rules govern the way in which a criminal action is tried in court? Now, I must advise you that, in my opinion, you will be far better defended by a trained lawyer than you can be by yourself. I think it is unwise of you to try to represent yourself. You're not familiar with the law. You're not familiar with court procedures. You're not familiar with the rules of evidence. I would strongly urge you not to try to represent yourself. Now, in light of all the penalties that you may suffer if you are found guilty, and in light of all the difficulties of representing yourself, is it still your desire to represent yourself and to give up your right to be represented by a lawyer?
I actually changed my mind after all of that.
Okay. So
Intimidated. All the way.
okay. So at this point, do you still want to try to hire an attorney?
Yeah, I hire one.
Okay. So we're gonna reset your case to give you an opportunity to hire your attorney. Give him a standard reset. Okay. Get your reset. You'll be free to go.
Okay.
And you have a blessed day.
All right, thank you.
Okay, you're welcome. Okay. We have, well, let me go ahead and do this. And Antonio Polero Alfaro. How do you pronounce your last name?
Alfaro.
Alfaro? Okay, now, Mr. Alfaro, you're represented in your case by your attorney Charles Rojas. And first of all, Mr. Alfaro, how are you doing?
I'm doing okay, Your Honor. How are you doing?
I'm doing fine, thanks for asking. And Mr. Rojas, how are you doing?
Doing well, Judge. Thank you.
Now, Mr. Rojas, and Mr. Williams, I have before me a motion to dismiss this case, stating that the defendant has paid restitution of fees. Is that correct, Mr. Williams?
That is correct, Your Honor.
And so, Mr. Alfaro, I'm signing this motion. Once I sign the order, you'll be able to get a copy of it from our court coordinator. Once you get a copy, you're free to go, and you have a blessed day.
You have a blessed day. too.
Thank you. You can stand in front of the court coordinator.
No, man, I got nothing.